All right. Good morning. Welcome back to day 6 of the Darrell Brooks trial in Waukesha, Wisconsin. Um, Yesterday was obviously an abbreviated session due to the tornado warning. And because it was abbreviated, court started early this morning. I forgot it started early. So we're a little bit behind again. We'll try to catch up in the breaks, if not at lunchtime. Uh, And because we're behind, I'm just going to jump right into it. So here we go. I hope. All right. There's Mr. Brooks. Um, we'll see what shenanigans he has. I wonder if he's going to cry about the Sixth Amendment again and wanting to subpoena the state of Wisconsin, which is ridiculous. As we discussed yesterday, the Sixth Amendment doesn't actually give you the right to face your accusers. It gives you the right to face the witnesses against you, which he's been cross-examining all of the witnesses against him. So Sixth Amendment wise, it's fine. And 2 days ago, Judge Darrell said, if you want to challenge jurisdiction, I've already decided, bring a written motion. Stop with these oral motions as the jury is walking into the courtroom, because it's ridiculous. It just it's prejudicial against him, but it's his own fault. So oh well. Um, Looks like I didn't fast forward quite far enough. So let's see. Still just Mr. Brooks sitting there pensively. Oh, his eyes are closed. Either he's asleep or he's crying. But fast forward a little bit more. Nope. Looks like the Howard Hamlin deputy is there today.
Versus Darrell.
Oh. All right.
State of Wisconsin versus
There we
Darrell
go.
Brooks, case number
Judge is
21
calling
CF
the case.
1848. May I have the appearances, please?
Good morning, Judge Sue Opper, Leslie Basie, and Zach Witchow appearing for the state of Wisconsin.
Good
Oh,
morning. Please state your name, sir.
Ms. Basie
I'm
isn't
here as
there
a
yet.
third-party intervener in that matter, appearing as authorized representative for my client.
That's not a
I
thing in
accept for
criminal
value in
law.
return for value all of the charging instruments in this matter and make my exemption available for the discharge of all obligations and charges connected with this case. I do
It's not a
dispute any of the
financial
facts
charge.
in the charging instruments, and for the record, I do not identify as that name nor consent to being called as that name.
Got to start with sovereign
The record
citizenry.
reflect that the individual known to this court as Darrell Brooks is present in person in custody. He is wearing street clothes. He's wearing a suit and tie. He's
Good
also
job,
wearing
Judge.
a mask.
Don't acknowledge his
All right.
nonsense.
We are
Just put
starting a little
everything on
bit
the
early
record.
today, given the extended break we had yesterday. Anything the parties wish to take up prior to the jury coming out from the state?
Morning, Darlene.
Just one thing, Your Honor, for
or
the
night, I
record,
guess,
we
for
have
you.
served all of the subpoenas for Mr. Brooks at his request. The subpoenas had indicated a report date and
I
time
forgot
of
they were
tomorrow,
starting early this
which would
morning.
be October 14th at 8 a.m. Given where we are in the case, we do not believe that we will have rested the state's case by 8 o'clock tomorrow morning. We believe we're probably on track to rest sometime on Monday at this point. So
Between the tornado
with
warning
the
and
court's permission, we would
Brooks
like
taking
to
10
advise
times
those
longer on
witnesses
cross,
that they do not
Of
have
course
to
they're
report at
behind.
8 a.m. tomorrow, and that we will update them probably Friday afternoon as to a date and time to appear.
All right, thank you. Any objection to that procedure, sir?
of course.
No objection. Just wanted to state that those subpoenas were filled out, as you know, by your assistants, that they should have been filed with the date of the 14th at 8:30 a.m. So just wanted to state that for the record. And also, again, I do not consent or agree to being called that name.
Who cares?
Your lack of consent is noted. I would note, though,
It's
you've not
noted
provided
and
me with a
irrelevant.
different name. Number one. Number two, every inmate communication form has the name Darrell Brooks Jr. So I like to refer to the defendants by their name, frankly, out of respect for them, to not continually use defendant over and over.
How's the future
Again,
treating you,
Not that that would
Darlene?
be improper, it's just a practice. So I'm going to still keep referring to you as Mr. Brooks. I know you as Mr. Brooks. Again, you've filed all sorts of inmate communication forms with that name, and you've never given me another name for which to call you. So I just want you to know that's not a disrespectful thing. It's out of respect for these proceedings.
She's not going to call you the
and,
third-party authorized
but
representative
at
for
times
the
I'll still
alleged
refer you as the
defendant
defendant.
who doesn't
No
exist.
disrespect taken whatsoever, Your Honor. And for the record, I still would not consent to that name
Who
or
cares?
agree to that name.
Give her a different
No
name.
respect, no disrespect taken whatsoever.
Your position is noted.
She's got to call you something. You
Right, do
you
you have
object
any
to be called
documents to file
the
today,
defendant.
sir?
You
Yes, I
object to
do.
be called
All right, can you hand
him.
that to the bailiff?
Just very brief things I would like to put on the record.
I'll have the bailiff
Oh,
first show it to
well,
the state. as
I hope
is
that you're
proper,
safe.
And then it'll come to me.
I hope not too much damage is done to your neighbors as well. We're in a terrible drought, so. All right. Oh, all three prosecutors are there now. Jury's been called, which means it's now time for him to start arguing about something like jurisdiction. If the past gives us any indication. Frankly, I'm shocked that he's not arguing about some nonsense right now. But it's still early. There's still plenty of time for him to argue nonsense, so I'm not going to pat him on the back or anything.
All right, the record to reflect, I have received a document that has a caption for this case, a heading that says bond. Then
He's going to
short
put a lien on
paragraphs
her
and then
bond.
a signature at the bottom with the name Darrell Edward Brooks Jr., authorized representative of Darrell E. Brooks, all rights reserved. I've reviewed it, sir. I would note it will be made part of the file. You do not.
I want to
reference
see
any
this document. I'm guessing he's trying to put a lien
law
on
as
her
it relates to this request,
bond, which
or what I would deem a request.
doesn't exist.
There's no constitutional provision, statutory provision, or common law associated with this. I'm not sure what you're asking me to do.
Did you
with it
mention
as
which
well.
area
I
of
don't
Australia
see
you're
a
in?
clear
Are,
request for relief as well. So
are you northern, like
it will
Northern
be
Territories,
filed.
Darwin,
I don't-
or?
I'm not going to address it any further. Do you want a copy of that for your records?
I've been
sir?
pretty much
Yes, I do,
ignoring the news
timestamp
except for
original copy,
this
if I
case.
may. And also, to my knowledge, the filing is proper.
To his
unless
knowledge.
Your Honor can
Did your prison lawyer tell you it's
provide
proper?
verified law of your own that is not a proper document. I think it's very clear what the document is referring to.
Okay.
The language is all together. It's a very, very clear document in it.
You say it's very, very clear.
And,
it's very, very
Direct your
clear
attention to section
if you believe in sovereign
802.01,
citizen
which governs
nonsense.
motions, how made, and the form. That document does not comply with that. As far as receiving a time stamped, we have a date stamp. It will be scanned and it will be then uploaded into the file. I would just note for the record, it's now 8:07 and I've had that for a couple of minutes now, but that's, we don't have a time stamp in the courtroom here.
what was the law that you cited?
I draw your attention to section 802.01, which is the statute related to motions.
And does that refer specifically to that filing?
It refers to how you file
It
motions.
refers to any request that's made to a judge or in a court of law. Could, I suppose, go to a court commissioner, but that's not where we're at in these proceedings.
And she can't
That,
give you
to me,
legal
does not
advice. You need to
provide
figure it out
a legal
yourself.
or factual basis for the request that you're making. So that's how I will address it.
For the record, I believe it does, Your Honor.
No, it doesn't.
It was presented in the same fashion that all my motions.
Well, all
in
your
this court
motions have been
presented,
wrong.
and, you never cited the same thing with the other filings, so that's leading me to believe that.
Aside
it's
from
just
which,
that document that's not being accepted.
what I'm
when I
guessing
have the
this
other timestamp
motion
filings for
is
the same
sovereign
documents
citizen
that I file. Every
bullshit.
other document is filed in the same manner. Every last one of them.
The
And
judge
no
doesn't
exception
have
with
a
that one.
bond. This is complete
I understand my
nonsense.
obligations with
She's
individuals
it's
who
a
are
waste of
representing
time.
themselves to review their pleadings and to construe them liberally. However, you were notified the other day that future requests
Exactly.
needed to comply with section 802.01. Even with a liberal reading of that document, I'm not sure what it is you're asking me. It's not going to prevent this court from proceeding forward and continuing on with the trial and having the jury brought in and the next witness called.
For the record, Your Honor, can you state why? Because it's clear what this is referring to.
It's
referring
clear to you.
why there's no bond
It's
mentioned
clear to
or
you.
stated in the
It's
court document.
It's because it's
the
not a thing.
docket sheet. There's no bond in any
It's
of
because it's not a
any of
thing.
these
It's
writings.
made up.
Not one time does it mention it.
It's not
And so
mentioned
that
because sovereign
Was what
citizens make this
was
up.
referring to.
I understand
what-
what it's referring to, so
They
sir, there's
don't-
no legal
They don't
basis
mention Peter
for your
Pan and
argument.
Neverland
So-
For the
either.
record, this docket is not a certified copy, which is what I requested.
I do not control the
Exactly,
clerk's
Darlene.
office. You
Like
need to
I've
make a
said
specific
many
request to the
times,
custodian of the
this
court
is a
record,
Brooks
which is the
problem,
clerk
not a
of
court
for a certified
problem.
copy.
I did
That
that,
can't
Your
be
Honor.
done here in this courtroom. You have to do that through an inmate communication form.
That's what I did, Your Honor. The ICF should be on record that I specifically requested. I specifically requested a certified copy.
Sir,
of
I'm
the
not
docket
in
sheet.
charge of
But
that,
that's
so I'm
not
not
a
going to address
thing.
that any further.
You
So my
requested a
understanding
certified
is a certified
copy
copy was provided
of nothing.
to.
It's not the certified
No.
copy that I'm holding, Your Honor. I know how a
Again, you
certified
can
copy
take that
is.
up with the clerk of court.
He
That
asked
is
for a
beyond,
certified
the
copy
scope of what
of
I am addressing
an
here. I
imaginary
am not the custodian
document.
of the record. I would not be the judge to address any concerns that you have if you believe your request was not complied with.
It clearly wasn't because this
I'm
is
not the
a-
person to do that, sir. It's not the proper
It wasn't
venue in
complied
this case
with,
or
but it
forum,
wouldn't be
right?
proper to
The
comply with
custodian
it
of the
because it's
record
not a
needs to
thing.
reply to that. That is our clerk of court. If you believe she did not do that, then you have recourse available to you, but it's not through this case. So with that, I'm going to move on. Let's have the jury brought out.
Why was I not provided with exactly what I asked for? If
Because
if
you're not
I'm told by the
entitled
court
to what
submit
you
a
asked
ICF
for.
for any requesting, and I requested specifically
I
a
request
certified
$100
copy
billion.
of the docket sheet,
I'm
and
not
was
going to
not
get
provided
it
with what I
because
specifically
I'm not
asked
entitled
for,
to it.
then
Sir,
how?
I can't address that any further. So
I
again,
would like
you need
that
to take
stated.
that up with the clerk of court, and you can communicate directly with her office.
Can
But I'm
that
not
be-
going to do it through this court proceeding.
I would like that stated for the record that I did not receive
You have
what I
stated it. It's
specifically
on the
asked for, and
record.
I'm sure
You're not
that the
entitled
ICF is
to
on
it.
record. I can get.
Mr. Brooks, for the record, we're on the record. And so
Okay.
everything that we're saying is on the record. So
Thank you,
it's noted.
Judge.
Bring the jury out, please.
Also, I have one more thing I wanted to state for the record,
Go ahead.
which was also submitted via inmate communication form.
And it's also
So that should be
complete
on
and utter nonsense.
the record, and it should be filed. I know it should have been received by now. It was addressed to Miss Monica Paz, and it was in it was asking for the complaint that was filed. It was 3 different complaints, and they're found in the docket sheet. One from 11/23 of 2021.
It's
One
in.
from
You have it.
11/29 of 2021, which would be the amended.
You
complaint,
have it. It's
and
in
then
your
one
boxes.
From January 12 of 2022, which would be the second.
If
amended
you've lost
complaint.
it,
I
it's your
specifically
fault.
asked
It's your
for,
problem.
Copies of those to be provided, as they were not in any discovery.
It's not discovery. The complaint isn't discovery.
Mr. Brooks, I am not going to answer for clerk of court Paz. She is the custodian of the record. All right. So you're going to have to communicate
Morning,
directly
Static.
with
We're a bit
her.
behind. I
If you're
forgot they
looking
started
for
early.
Just copies.
So we're
I'm
catching
happy to
up
print
too.
those off for you. I've already provided some of those things to you. I hear you saying you want certified copies. That would not be provided by me. Are you looking for certified copies or just copies?
Certified copies.
All right, then that will have to be addressed by clerk of court Paz.
So how would I do that? Because
I can't, sir, I've
is it
already
a
bit
told you
chilly
you need to
this
make the
morning,
request to
Static?
her.
I hope
If you, and
you're not shivering there on the farm.
that's how I have to leave it, sir. I'm not the custodian of the record, so.
I addressed it that way, Your Honor. I addressed it the way I was told to address it from
My
the court.
understanding is it
So
went to her.
complain to
with
the
that,
clerk
let's
of
have the jury
court.
brought out.
She
Your
told you.
position's
It's not-
noted.
She's not
Your
involved.
Honor, can we address the subject matter jurisdiction? before
No,
the juror comes out?
it's
Jury
been
comes out?
addressed. She's
And
ruled.
Is that a judicial determination that you're making? Not
She has
to address
ruled
the subject
that she
matter
has
jurisdiction, which has yet to
jurisdiction.
be proven at this point. It
You-
has not been
she
verified.
doesn't have
Please,
to
the jury's
prove it.
coming out. I know what you're
And
doing,
you
but just-
haven't filed the
I've already
motion
addressed
she
that.
told you
So
to
is that a
file if you
judicial
want to
determination
argue
that
it.
you're making?
My decision on the record stands, sir.
And I would like the record to reflect that you have not shown verified proof of subject matter jurisdiction.
She doesn't have to. You haven't proved that she
And
doesn't have
that
jurisdiction.
By refusing
That's
to
how it
answer,
works.
That is a tacit agreement by you, Your Honor.
tacit
which you understand
agreement?
what
No,
that
it's
means. I
not.
know you do.
Just because
Mr. Brooks, I
sovereign
have not
citizens
entered into
say
any such
failure
agreement,
to
and because the
respond
jury
is
out
agreement,
and you
it
are
is
claiming
not.
that there's some issue.
Stop.
I'm going to take this up later, but I will entertain a request from the state for a curative jury instruction. All right, thank you, everyone. You may be seated, and welcome back, ladies and gentlemen of the jury. We are proceeding with this trial, and the state may call its next witness.
And Your Honor, before the state calls the next witness, I just want to let the record reflect that I did put Exhibit 54 on the witness stand. And it will be introduced through the next witness, who is Laura Thiem.
All right, thank you.
Are we on to the dancing grannies now?
Good morning, Ms. Thiem. If you would please make your way to my witness stand, which is all the way up by me. It is up one riser. When you get there, please remain standing. Raise your right hand. My clerk, Teresa, will swear you in.
Good morning, Steve. Like I said the other
Do
day,
you solemnly swear
I'm told Wyoming doesn't exist either, yet most of my vacations have been to
Thank you. Please be
Wyoming.
seated.
Apparently, I was in the void.
First thing I will ask you to do is to state your first and last names for the record and spell each.
She's definitely
Laura, Laura.
on the older end of the spectrum, this
Thien,
new witness.
Thein.
So she could be a
Thank
dancing
you.
granny.
Sorry, I put an M on that previously. All right, go ahead, your witness.
Good morning, Mrs. Thien. How are you today?
Very good.
Okay. Ma'am, I'm going to direct your attention to November 21st, 2021. Were you at the City of Waukesha Christmas Parade on that day?
Yes.
Were you there as a spectator?
No, I was in the parade. I
I'm not
was in
fully
one of the
convinced he
units.
can
Okay.
read,
And which group were you
Darlene.
with?
The Milwaukee Dancing Grannies.
I think it was his
How long were
jailhouse
you
lawyer,
with the Milwaukee Dancing Grannies?
How long?
Yes.
because that's
8
how
years.
sovereign citizenry spreads
And
into jail.
how would you describe, first of all, how many people at that time were in the Dancing Grannies approximately?
There were 9 of us in the parade.
And
Can you
he killed
describe,
4 of
were
the
you
9.
Were you guys friends, close? Did you see each other often?
We were like sisters. We were a sisterhood
Did you meet regularly for practices?
every week.
Okay. Without fail, pretty much?
And we had some social outings. And then we've seen each other again every weekend for a parade.
So would it be fair to say that the 9 people that were at the parade on November 21st, you knew pretty well?
Very well.
Is it normal for the dancing grannies to be part of parades?
Oh, yes. We do lots of parades. We do about 21 of them in summer and about 5 to 6 in winter.
Oh, wow. That's every other week. If you
Did you talked about
spread it out
practices, did you
evenly.
have certain numbers that you did for example, for the Christmas parade this past year in November?
Yes.
the
we do
opening, they stated it
Christmas
was
routines.
walking
and
in a winter
Christmas-
wonderland
for the holidays.
was their routine
And then
they
we
were
do
doing
different type
at
of
the time.
routines for summer.
In November, would you have a pretty standard formation that you would keep to do each of your routines during the parade?
Yes.
Did you have uniforms?
Yes, we did.
Can you describe them for the jury?
Objection, relevant.
It's not irrelevant. It identifies where they are in
They
the
were
parade.
long skirts with white fur. They were blue with white fur on the bottom. Blue jackets with white fur for cuffs and around the neck, and a white fur hat.
To me,
Did you have,
the
I'm
pictures
assuming
I've
if you were
seen,
dancing to music, that
it's
you
like
had
a
something that played the
Mrs.
music.
Claus
Yes,
in
we have a
blue.
music vehicle
Where would that music vehicle be in relationship to the group who was performing?
right behind the group.
Oh, hold on, there's been an objection. It's noted.
It's a
overruled, so
frivolous
answer may
objection.
stand. Just in the future, if there is an objection, wait until I've ruled on it and then answer.
He
if I say,
objected so quietly
overruled.
that
Okay.
she wouldn't have heard.
Relevant.
Grounds for the relevancy.
Because it's relevant. She doesn't have to state her
So
grounds.
did you also have people walking with the performers in the parade to give support?
He's such a clown.
Yes, we have volunteers. We have 2 volunteers that carry the banner and a volunteer that will give us ice chips in case we get.
Do you recall who were the 2 volunteers who were carrying the banner that day?
Yes, there was our usual banner carrier, a young girl, Allie, and then at the last minute, the gal didn't show up because we have 2 for the banner. She didn't show up. So Ginny, at the last minute, decided to be the other banner
And
carrier.
Ginny was
And
one
when
of
you
the
say Ginny, are you
fatalities.
referring to Virginia Sorensen?
Yes,
And you knew her as Ginny?
yes,
You
Keyword
said there's
knew
also
her.
another support person who carried ice chips.
yes.
Do you know who that was last year?
Objection, relevancy.
Overruled. You may
Yes.
answer.
Grounds for the overrule.
Because it's
I should-
relevant.
You can answer.
Okay, yes.
Who,
Bill,
who was
one
there
of
is
our
highly
dancing
relevant.
granny's husbands.
Is that Wilhelm Haspel? Is that his full name?
Yes.
Thank you.
And I believe he was
Now
killed.
I have before you a document that's marked States Exhibit 54.
Because, yeah, Bill Huskell.
Do you see that
So
in front of
3
you?
dancing grannies, 4
Yes,
in the
that's pretty much our group.
Okay, so it consists of 9 different, it looks, why don't you describe for the jury exactly what's in front of you?
Overruled.
He
Wow.
doesn't. You didn't give grounds for the objection.
Okay, we have 9 people that were in the parade. And when there are an uneven number,
Stop
there
interrupting,
is
Brooks.
somebody who is in the slot.
You're such a clown.
And it was my turn to be in the slot. So
Okay.
What do you mean by
So
slot?
on the top of the sheet, and I have a copy in front of me. So if we're going from the top down, we have the names. It says banner, and then on the left-hand side, as I'm looking at that, it's Ginny Sorensen and Allie. Is that correct?
yes,
And I'm going to actually ask that this be published also for the jury and admitted into evidence.
We have yet to see what's being talked about being shown.
You have the exhibit, I guarantee.
Does Mr.
It's up.
Brooks have a copy?
I believe it's up in front of him now.
All right, give him a minute to look at it.
Not consent to being called that name, nor do I agree to being called that name.
Right, the record should reflect that
It's
the
definitely better sleeping.
exhibit
in the cold than in the
54
heat
is being
static.
displayed on the monitors
You can always add
Present
another
time
blanket.
to the parties,
You
to the
can't.
court,
You can
and to
only
the
take so
witness.
many off.
There's been an offer or a request by the state that the court receive the exhibit.
It does make getting out of bed harder,
Based upon
though.
the testimony of this witness, exhibit 54 is received, permission to publish is granted. Noted. Overruled.
On what grounds?
Mr. Brooks, I'm not going to be specifically addressing, so please respect that.
I respectfully request a legal reconsideration of your ruling.
Mr. Brooks, now is not the time.
Just
for
shut
that.
up.
The objection has been overruled. I expect that you will honor
This is
that,
just
and we will continue
intransigence
without
at this
interruption. Go
time.
ahead.
I do honor it, Your Honor.
You
For the
don't.
record, I respectfully reject that ruling and take exception to that ruling.
You're not being respectful. You're being
So in the upper
argumentative.
left-hand corner, the name
This
is
isn't
Ginny
the time for
Sorensen.
argument.
In the middle, it says banner and then Allie. Ginny was Virginia Sorensen. She was carrying the banner with Allie, correct?
yes,
And they would be in the front as the group is going down the parade route.
yes.
And the 9 people who are listed in the boxes following or behind the banner, does that accurately reflect the lineup that you had on November 21st of last year?
Yes.
Overruled.
It's completely relevant because it shows where people were when you ran
I'm
them
now going to show the
over.
witness exhibit 53, just the witness only.
Go ahead.
And let me know when you see it up on your screen.
But clearly, to
So,
Brooks,
okay.
nothing's relevant.
I'm going to show you a couple seconds of it. I'm just going to ask you if this accurately depicts
Except for
your
window
group
tint
on
and
November
horn
21st of last
honking.
year. So I'm going to play a couple seconds. It's starting at 00, and let's play it for 5 seconds.
This is my group coming up.
She's identifying the
Does that
video.
accurately reflects how your group on November 21st of last year? Okay.
Sorry, you were shaking your head. Yes, is that a yes?
Yes, that's how it was.
Thank you.
Need a verbal
Oh,
response.
I'm sorry, I should have said that out loud.
It's okay.
That's okay.
That's what I'm here for, to make sure the record's clear.
Okay,
I would ask the court to
Testifying
admit
isn't a conversation,
exhibit 53 into evidence and publish it for the jury.
which is difficult for.
Overruled exhibit
Witnesses.
53 is received, permission to publish is granted.
Grounds for the overrule.
You didn't give grounds for your objection.
Ma'am, I'm going to play it straight through and then we'll go back and go through it and pause it occasionally for you and to identify everyone, okay?
Grounds for the overrule, Your Honor.
The statement continue.
She
Is that a legal determination that you
Yeah.
don't have to give me the grounds?
she
for the-
doesn't have to explain it to
Overruled.
you.
as
You
I
didn't give grounds for
objected
your
on the record?
objection.
Stop interrupting. I made my
Stop.
ruling. Let's keep going. Go ahead.
Thank you.
I asked for a written judicial finding of facts and conclusion of
No.
law.
No, you
Or is that a
can't.
tactic agreement, Your Honor?
banner, just for the record, this is 1 minute and 27 seconds left.
I'm ready to, well, I am screaming. I'm ready to pull out my hair. And good morning, Steve. I think, well, I already said good morning, so yeah. Exactly, Steve. Do all the YouTube-y stuff, and bribe your friends to do the same. It's amazing how Brooks just gets worse and worse. More argumentative, more ridiculous. You wouldn't think that was possible as time goes on, but... Uh-oh. That's probably copyrighted. I guess I better... La 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 la. Don't listen to the music. YouTube bots that this isn't. No.
Bam, that was the routine at the beginning of the parade, it looks like. Is that
Yes.
correct? And will you be able to identify each of the people if I go through the exhibit and kind of pause it occasionally for you to tell us who they are and a little bit about them?
Objection, hearsay.
Thank you.
It's not
Overruled.
hearsay.
Grounds for the overrule.
Because it's not hearsay.
Not hearsay.
But why isn't it
Okay, so I
hearsay?
ask that we begin playing it without sound at 00.
I mean, he still hasn't read what hearsay is, I
If we can
guarantee.
pause it.
He's
Again,
been
can you circle?
busy
Virginia Sorensen
learning
on the screen?
about the
screen in front
judicial
of you
bonds
is
that
touch.
doesn't
Okay.
exist, instead
This
of
is
reading
Ginny.
about hearsay.
Can you tell us a little bit about Ginny?
Ginny was our glue. She held the group together. She was in the group the longest. And I think she was in the group for close to 20 years.
Wow.
So she was in there for a long time. She was close to everybody. Like I say, we were like sisters. And if you had a problem, she would always ask you about it, talk to you about it. Ginny was always there.
If we can continue on, it stopped, I'm sorry, at 1 second. If we can continue on from 1 second.
And we are seeing video.
If we can pause it.
Okay.
I don't
and
know
now
if-
that's
Well,
Lee
they
and
won't show
Sharon.
us.
Okay, so who is on, as
The
we're looking at
carnage.
this video, who's on the right side?
The right side would be Sharon. Lee is on the left. She was right behind Ginny.
And I'm just going to direct you to Exhibit 54.
I'm
That's in front
sorry,
of you.
I didn't hear you.
Oh, I'm sorry. Maybe I misunderstood. When you say the left side of the street was where Lee Owen was, or the left side of the picture as you're looking at your screen?
Lee was on
It's
the
not-
left,
it's
right
not
behind
leading.
Ginny.
Miss B,
Oops.
it's okay. There's been an objection. It's overruled, but I would caution the state about leaving the witness.
It wasn't
You
leading.
may answer.
Okay, so
Okay.
right behind Ginny was Lee Owen.
Yes,
Is her full name Leanna Owen?
Lee was
Overruled.
very close to Ginny. They worked together a lot for the
Stop
group
talking, Brooks.
and for
Stop
she
talking.
talked a lot for
witness
the
is
new
talking. She's
people that were
testifying.
coming in. She was more or less the leader to teach them the routines. And I rode with Ginny to not Ginny, but Lee. I rode with her to every practice. We rode together. So we were quite close too.
Okay. And next to Lee, you stated according to Exhibit 54, that would be Sharon Millard.
Yes.
Okay. And I'm going to focus on the people that were injured during the parade, okay? So next, if we can continue on, we stopped
Before you move on, can you tell me where that was paused?
at 11 seconds.
Thank you.
If you continue on from 11 seconds. And pause. The state has paused at 21 seconds.
So the fatalities associated with
Okay.
dancing
There's
grannies
a
are
woman who seems
Ginny
to be between,
Sorensen,
in
Lee
back
Owen,
of,
Bill
Lee and
Huspel,
Sharon.
who was the
Recognize that
volunteer.
person.
and I think
That would
Tamara
be Betty.
Durand.
And do you know Betty's last name?
Betty String.
Okay. And did you know her very well?
She was fairly new. She was only in the group for a couple years.
A couple
And
of years
so-
is new in
but
this
We
group.
knew each other quite well.
Would she go out on the events with you and you do social events?
Absolutely.
Okay. And I think I said it, I stopped at 21 seconds. If we can continue on. We can pause it. The state has paused at 28 seconds. Behind Betty, there are two women who are in the forefront of the video that
Mhm.
stopped. The person that would be dancing on the left-hand side of the street as you're walking down the street, do you know who that is?
That would be Kathy Schmeling. This was her first parade.
Can you circle her where she's standing?
I was about to say
Okay.
they should
If I go
utilize the
way,
touch
she's
screen to
going
clarify when
on
she
the right
says
side or
left side
left?
or left side.
Circle who you think is Kathy Schmeling.
Tell her it's
okay.
a touch screen.
Kathy would be on the, on the right. She would be right there.
Okay. And
So right side
you said the
marching,
other person
left
was
side
who?
of the screen.
Lola
Okay, can you circle Lola?
Hospel. She is the wife
So her husband was the
Bill
volunteer
that
killed.
was hit.
Okay.
Objection, that wasn't the question.
She was
Noted.
identifying
It's-
her.
Overruled. Her answer may stand. Next question.
Grounds.
And you stated that Wilhelm or Bill was a support person that was marching the parade that day.
Yes.
What did you know about Lola?
Lola was the mother figure. She was, I think, the oldest,
The mother
in the
figure to the
grannies.
grannies.
and she was rather on the quiet side, but she was just friendly with everyone.
Was she in the grannies when you joined 8 years?
Oh, yeah, she was in quite a long
I
time.
like this
similar
witness.
to Ginny.
I like this witness.
So continuing on from 28
She seems
seconds,
so
I'd ask,
friendly
that we continue.
and eager to give
pause.
information. I think the
State
jury's
paused at
eating this
34
up.
Seconds. Can you identify the person who is behind Lola and Kathy in the video?
Yeah, she would be in the middle. That is.
Hold on.
Morning,
There's an
C.
objection. It's overruled.
Grounds.
She may answer.
Grounds.
He's
Tomorrow.
being extremely argumentative.
Rosentier, it's hard to pronounce her name, but
Brought up
Rosentier.
Subject
Rosentrier?
matter
That
jurisdiction as
sounds
the jury was on its way
Okay.
out
Can
again.
you circle her on the
No,
screen?
no written motion though,
That's her.
and
right
he's
Okay. And what can you tell
complaining
us
now
about,
because he did
Ms.
file
Rosentreater?
an improper written
there.
motion
She was
asking for the judge's
I
bond.
would
I'm
say
assuming
about
for the judge's
5
bond,
years.
which doesn't
into the
exist,
group,
but
4
sovereign
or 5
citizen
years.
lore says that
Yeah.
it does.
Fun person,
So-
very friendly.
He's just been
All of
awful.
us are very
He-
friendly.
Okay.
He's on
You
one.
seem like you might be.
Yeah.
Okay, if we can clear the screen and continue from
And yes,
34 seconds.
we are talking dancing grannies now. She's one of them. She seems like she's such a sweetheart. I love her.
And if we can pause the screen here.
Okay,
Okay, the next two people are behind Ms. Rosentreater.
Tamara, yeah,
And can you identify those people?
yes. This is Tamara Duran.
Exactly,
Two Tamaras on
Darlene.
your team?
Yes, we do.
Okay.
There were
And
9
2
dancing
Kathys,
grannies.
too.
3 are
Okay.
dead.
And this
And
is Kathy.
One of the survivors lost her husband, who was a
Zartek?
volunteer.
Zartek or
It-
Leading the
something
witness.
like that.
Hold on. There has been an objection.
Okay.
I'll sustain the objection on leading grounds. Her answer may stand, but I would again caution the state to.
And I would just note for the record, Exhibit 54 is in front of this witness, and it does have the first and last names, and she's already said that it accurately reflects the people who are marching
It's
with the
Florida.
dancing grannies on November 21st of last
We
year.
don't need to be in suspense.
That was not the question.
Cruz.
Who's leading?
Understood.
Cruz will live 40 years on
For
death
purposes
row.
of identification, now
my
I'm going to instruct her to
prediction.
turn the Exhibit 54 over to make sure that her testimony today is from her recollection and not from reading from a form. So if you could turn that over, please. The paper document that you have. There you go. Thank you. Go ahead.
Now you circled, can you circle Tamara Durand again, Tamara?
Okay, this is Tamara Duran.
Okay. What
This
you-
would be Kathy Z.
Okay. Direct your attention to Miss Durand. Can you tell us a little bit about her?
Tamara Durand is one
I'm
of the
sorry.
fatalities.
Directing your attention to Miss Durand. Can you tell
Yes.
us a little bit about her?
She was new, and this again was her first parade. She was so
First and
excited
last.
about being a granny because she had worked for months and months to learn all the routines. And when she knew she would be in that Christmas parade, she was so excited. She just couldn't wait. So she was looking forward to doing all the parades. That was the first and last parade she ever did.
If we can clear the screen and continue on with the video from 42 seconds.
You mean Sideshow Bob? He's not Ronnie O'Neal. He's Sideshow Bob. And frankly, you know, I've said earlier, I'm not a fan of the death penalty. I'd actually rather have
Pause it.
Cruz spend
Last
100
but not
years
least-
in
Okay, you
general
get this one.
population.
Okay, that's you.
That's me.
Okay, if you can circle you on the diagram, I think there's only one person in
Because
it.
I think
And you
for
said you've been
him,
with the Dancing Grannies for 8 years, correct?
an
Yes.
injection would
You
be
can clear this,
the
and
easy
I
way
stopped
out.
it at 1 minute and 9 seconds. If we can continue forward.
so. My objection to the death penalty is part
I'm going to pause.
That's the music.
not
field.
liking
Who drove that vehicle on that day?
revenge, brutality,
Pardon?
but
Who drove the
also
vehicle on that day?
I
My
think it's the
husband.
easy way out.
And you see a figure entering into the screenshot. Do you know who that is?
This would be Bill.
Thank you. And that's Bill Wilhelm. Do
Pardon?
you know the last name?
He wasn't
It's been reversed.
screaming.
Bill.
He was just
That would be Bill
speaking in all
Hostel.
caps.
And do you recall him wearing a hat that day, as shown in the picture?
And since it was in all
Objection,
caps,
leading the witness.
it's a straw man, so it wasn't
Brown.
him.
Relevance. You may answer.
Okay, Bill was just walking up behind Tamara Duran, and
I had to
gonna
share the
be
Ronnie
offering
O'Neal
her some
closing
I'm not sure you heard the
arguments
question. If
with
the
my
state could
friend.
re-ask it.
And we had tears in our eyes. It was
And looking at the picture, was
Such a
Mr.
mess.
Hassel wearing a hat that day?
Oh, I'm sorry. Yes,
Okay. And during pretty much the entire route of the parade, was he usually in back of you
the
or
thing
in
is,
front
Steve.
of your position?
I don't know. Part of me,
he's on the side of us.
she has problems as a witness.
And
She's
usually
not
on the-
always answering the
side that
questions
he's on
directly.
right now?
She's
Sometimes he
but
would be
the
on
jury's
the other.
eating it up.
It just
So,
depended how many
she's
people
such
we
an
had to
effective
give
witness.
ice on any particular parade.
Okay. And was it cold that day? Do you remember?
Yes, it was pretty cold.
Yep,
Okay.
they
I did
edited the
stop
video.
at 1
clearly.
minute and 20 seconds.
Just like all these
I'm
videos are
just-
edited.
At some point during the parade, did you hear, strike that. Were you always, with the formation that you've testified about, were you
Yep,
always the
that's
last
evil.
dancer in the formation?
No,
On November
I'm glad
21st,
that
2021, were you the
has a
last
good
dancer in the
family
formation
now.
throughout that parade route?
for this parade I was.
Okay.
we took, if there's an even number, nobody is in the slot. But if there's an odd number, there was no partner. So we just would take turns. Each different person at each different
Exactly.
parade would be in the slot.
Made the trial
So
a
at
little
some
bit
point, did you hear
awkward.
something
but
unusual
I'm
behind you?
I'm
during
happy
the
for
parade?
him that
No, because the music vehicle
Yeah,
was
I'm
right
hap-
behind me.
I'm glad they
Did
adopted
you
him.
at any time turn around and see something unusual?
Yeah, as we were going and I was dancing, when I would I seen a streak of red coming on my right side.
How fast was that streak of red going?
It was going pretty fast.
It's not
The
hearsay.
objection's noted.
It's
It's
her
overruled. Her
observation.
answer may stand.
Grounds for the overrule.
Because it's
Oh,
not
it's-
hearsay.
So your answer stands, which you said it was going pretty fast?
Yes, it just like whizzed past
At
me.
some
It
point, he needs to
wasn't
listen to
just
her
going slow.
when she says
As
she
it was
doesn't
going
have to
past you,
explain
who was in the
every
area?
ruling.
Prior to it going past you on, and I'm assuming you lifted your right arm, was that on your right side as you were marching down Main Street?
Yes,
Who was in that area prior to that red streak coming through?
kitty corner for me, that would be Bill and Tamara Darrell.
Did you get the opportunity to see what that red streak was?
Yeah, and shortly, in a few seconds later, the red vehicle was right in front of me,
Exactly.
going down the center.
You understand this
To
sovereign
me,
citizen
just
nonsense.
pointing to the center of the parade route.
So right in front of you.
Yes,
To
How
the
close
extent
did
it
that
can
red
be
streak come to
understood.
you?
I would say a few feet. He had to go around the car, the music vehicle,
Okay.
and then
That's a
the
good fact.
right on the right side.
He avoided
and
vehicles,
that's
but
when
not people.
Bill and Tamara were hit.
So when you were in front, or I'm sorry, in the back of the parade lineup, how
That's
far were
because
you
the
directly in
delicious
front of the
corpses
music
were
hall?
left on the ground at the parade.
Several feet.
And the red vehicle that you've identified, it went to the right of
It
the
came
music truck?
from the right side, yes.
And you stated it hit Bill and Tamara, correct?
They were the first ones, because they were
I
just
think
kitty
I would
corner
lose
from
my
me.
mind, though, if he did
Several
bring
feet.
up corpus
Then where
delicti.
did it go?
Although he has
Then I noticed,
said, show me the
I didn't
victims,
see them get hit.
or
'cause
something
It
to that
all
effect.
happened so quick that I was still dancing. And all of a sudden, I seen the red car in front of me. And I screamed either in my head or out loud. I don't know which. But I said, what is he doing? Where's he going? And I just screamed it because it was so unusual. And I knew if he was going down the center of the parade route, he was going to be hurting a lot of people.
Yep.
And he wasn't going slow. He was going at a good clip.
Did, from the time that you saw the red vehicle on your right, striking Bill and Tamara, did you see it slow down at all?
Did I what?
See the vehicle slow down?
No, it just hit them. And as he was coming in, he started then going toward
Well,
the middle where he hit two more
I don't
people.
think I've ever seen
and
one
then
in the
veered to the
wild.
left and killed two
Of course,
more.
Utah's so
You said it was a
homogeneously.
red vehicle.
lily
Did you get
white.
a general description of the
We have
vehicle?
a
What type of
good
was it a car,
Hispanic
a sedan,
population and a
pickup
good
truck?
No, it was
Pacific
like a
Islander
SUV
population.
or something. It was wasn't just
But
a car. It was a van or
we don't have
something on
many
that, or
Moors here
SUV.
just due to
So as the vehicle
demographics.
went through, did it stop?
We do have a
after
lot of
it,
sovereign citizens,
struck, I
though.
think you said it struck the people in the front. Who were the people that you just testified to that died?
Objection, leading witness.
Overruled.
Grounds.
Because it's not
he
leading
came
the
from
witness.
the right,
Oh.
hit two.
Oh, one moment.
Whoops.
Sorry.
Who's not leading? Go ahead. You may answer.
It came from the right, hit two people, and then veered toward the middle. And that's when I really seen him. And then hit two more people, veered to the left and hit two more.
And the last two people that were struck, do you know who those people were?
Yes, I believe they were Ginny and Lee.
And you testify that both of those people died as a result of being struck?
They were killed instantly. And because the car came from the
Hold on.
back, oops,
That's okay. There's not a question. Wait till the question is asked.
okay.
After the car struck Ginny, and she would have been in the front of the parade still carrying the banner, is that correct?
Yes, she was on the far
Of
left.
course, 'cause
right in
every
front of
Moore
Ginny.
Is an
After that
ambassador or a
occurred,
governor or a
Did you see the vehicle
grand
stop?
poobah
No.
or
Vehicle kept
something.
going?
Yes,
Did you see the path of travel it took after it struck Ginny?
well, after it struck Ginny,
Like the
was
Republic
sort
of
of on
New
the left
Jersey
side
has
of the
about
street,
87
and it
governors.
just kept barreling through.
I'm going to bring up Exhibit 54 again,
Go ahead.
and I'd ask that be published to the jury. It's previously been admitted into evidence.
Go ahead.
Objection. What's the relevancy of the video?
So Exhibit 54, the court's already
Yes,
admitted
Steve,
it.
there are
It's shown to the
polygamous
jury. Go
compounds.
ahead.
Ma'am, can you?
I don't know of any
when
in
the
my
car went through,
neighborhood.
Can you
There used to be one
approximate
down by
where
Liberty
Bill
Park,
was
which is the big
on
park
this
in the
chart? You
sort
could
of
put an
central
X where you
city
think he
area.
was.
But
Bill
Bluffdale,
was about
what
here.
southwest
the
corner of
sheet
the Salt
wasn't
Lake
being
Valley
shown.
does, and then southern Utah is just full
You
of them.
specifically made a ruling for the sheet to be turned over.
That was during her testimony. She's now being asked to annotate the exhibit. So it's proper. Your objection's noted. It's overruled. Go ahead.
And this could be true,
Can
Darlene.
you, show the
Sometimes
jury using this
lower
chart, maybe you just using a line, the
Tones,
path
more
that the
more
red
bass tones
vehicle took?
are easier on older ears to hear.
It struck there, hit Tamara, Betty,
I mean,
Lee, and then Ginny.
people who
If we can take a screenshot
understand
of that,
reality
and it
are
would
paying
be State's
attention.
Exhibit 54A, I believe.
Oh,
So he drove diagonally
And you
across
say
the
after it struck
dancing
your group, it
grannies.
continued going in the left-hand
Yes,
side. Do you know what group was in front of you?
what was in,
I'm sorry, do you know what parade group was in front of the dancing grannies?
um,
And if you don't remember, that's okay.
yeah, I'm not real sure.
That's fine.
For the record, the court did capture the annotation and marked it as 54A.
Good job, court.
After the vehicle went by, what did you do?
After when I noticed that vehicle in front of me, and then it went toward the left and continued going down, it all happened in a matter of seconds. And after the car kept going, I looked on the road, and all I seen were bodies.
But
I
what
thought
did
I
you
was in a
do is the
war
question.
because there were just so
I
many.
guess she answered. She looked
And
down.
I just went into shock, and I just grabbed my jacket like this and went to each body to see who it
If
was and
he
if I could help.
Calls himself as a
Okay,
witness.
you said that you grabbed your jacket.
He
you held
testifies
both,
in narrative.
sides of your jacket
So
up
he
to your
doesn't
neck
ask
area. Would
himself
that be a fair
questions.
statement?
Yes,
The-
I just,
The judge
I
will
think
tell
I
the
needed-
jury,
The objection's
Mr. Brooks
noted.
is going to testify
overruled.
in
Her
narrative.
answer and the description
um,
provided for the record
Blah blah blah.
by Attorney
And
Daisy.
then he'll just
accurate.
tell his story.
You may continue.
But the
Grounds for the
prosecution can still
overrule.
object if he's getting into
Already noted.
inadmissible
Go ahead. Attorney
stuff.
Daisy.
And they still
said
get
that
to
you were in
cross-examine
shock.
him.
I just went into shock seeing the bodies. I needed to hold on to something, I think. So I just grabbed this and just went from body to body. And then the people were running into the road
I don't
with
know the rules in
blankets
the
and
Wisconsin
the,
court. I don't think there's a time
anybody
limit.
that was in the medical
But
group
at some point,
quick
if he's
came and were helping
just
the
constantly
people that
going
were
into
laying in the road.
irrelevant
to see
stop.
if they could
The judge
help.
can just shut
The
him
people
down
that
like
you
she
saw laying in
has
the road,
on
were all of those
cross
people from
examinations.
your group?
Objection,
Yes.
hearsay.
Overruled, not hearsay. Just a reminder, once again, let me rule on the objection before you answer. It's okay.
I'm sorry.
Once again, it's not a conversation. Pause and then
Can
answer.
you walk us through who you went up to
It's
and
not
what you
natural
observed
testifying.
after you said you started going to each of the bodies to check and see if you could help?
Like I say, the people from the sidewalk, they just ran into the road to help.
Spectators?
Spectators from the sidewalk, yes. They were wonderful to try to help, bringing blankets to cover the people, to keep them warm. Then there was someone from I think it was the tavern,
And the
bar
judge
right
will shut
there,
him down before
And
he finishes
someone
page
came
one if
out
he does
and
that.
had us kind of
Aside from which,
corralled us,
you have to
me,
testify from
Sharon,
memory, so
and
he can't read
Kathy
it anyway.
into the tavern to give us some warm coffee or something to drink. But I couldn't stay in there. I had to be out there, and I had to know what was going on and how badly anybody was hurt.
So when you came out, who did you go up to?
Then I went back. I was on the road again, and just looking who was being helped and who was not quite
But who did you go
being
to?
helped yet.
She needs to be
And
sure
how
to answer
badly
the
they were hurt.
question
I could
specifically.
not even find Tamara and Lee.
Okay. And when you say Tamara Durand or Tamara Rosentreater?
Durand.
Okay. So you couldn't find Tamara or Lee Owen?
Say no.
Sorry.
Don't.
Did you hear
shake
her
your
ask,
head.
was that Lee Owen?
Oh, I'm sorry. Yes, the two of them. I couldn't find. The rest of the people were accounted for, but I didn't know where they were. So when they were hit, they went flying on the sidewalk.
So
And that's why I didn't see them on the road.
okay. You said yourself, Kathy Zadarsdek, Kathy Schmaling, the three of you went into the bar initially. Is that correct?
When they came out, they told us, come on in here and get warm and have something warm to
And
drink.
you did go in.
Were you injured as a result did you get struck by the red vehicle?
No,
Did you see injuries, or do you know if Kathy Schmaling or Kathy Zadarsdek got hit by the red vehicle?
I don't believe so, because Sharon, Kathy, and I were, Kathy Z, were kind of walking in the road trying to see if everyone was being helped.
How about you said Sharon was also looking to see if people were being helped. Did you
Yes.
observe any injuries on Sharon?
No. We were the three more or less and the fourth one was Kathy Schmeling, and she immediately went on the sidewalk, and I think it was a sister or someone was
It's gibberish.
on the
So, it
sidewalk
works.
watching the parade. She quick ran up to Kathy and took Kathy right home.
Kathy's sister, Kathy Schmaling's sister, took Kathy Schmaling home?
Yes, because she was crying, standing there on the
In shock.
sidewalk, and she was kind of uncontrollable.
Okay.
I would be
So
too.
let's go. Who were the first people that you saw as you walked out to check on people?
No, Steve, I want to bake her cookies.
Sharon, I seen her.
I'm sorry, of the injured people.
Oh,
Who did you see of the injured people?
She might not want to eat
approximately
my
where
cookies,
were they
though.
and
They're
what did
not
you
usually
observe?
very
okay.
good.
I went straight ahead, and it was mainly Tamara.
Rosentreater?
Yes, and then it was Betty String.
Were they both on the ground?
Yes, they were laying in the road.
Did you see, were they
And-
able to move?
Pardon?
Were they able to move?
Not much, because the people were telling them to lay still, because I believe Betty had 2 skull fractures,
Ow.
and they didn't want her to move her head or anything. But yet she was awake and she could talk. So
How about Tamara Rosentreater?
now she had several broken bones, ribs, arm and wrist, leg. So she had a lot of broken bones, but she too could talk and communicate.
How about Lola Haspel?
Lola immediately ran to her husband. He was laying kind of on the sidewalk because when he was hit, he just went toward the sidewalk. And now he was hurt. He wasn't killed instantly. And she had a blanket for him and she stayed with him until the ambulance came and took him to the hospital.
Did Bill recover
No.
from the injuries sustained by that vehicle?
No, he didn't. He died during surgery.
Did you note any injuries or find out of any injuries to Lola Haspel?
No,
And Lee Owen, you said you could not find. Did you find Lee at all that evening?
yes. Later, the police had me identify her. They had her picture on their phone. And because I asked where Lee was, and they showed me, is this Lee? And
And she was
it
dead.
was her. She was thrown on the sidewalk.
Oh.
That's why I didn't see her in the road.
Do you know what side of the sidewalk she was, or what side of the road she was thrown on?
She was on the left.
So as you're marching down Main Street, she was on the left side?
Yes, she was right behind Ginny.
And he
And
cut
the picture
across
that they showed you of
diagonal
Lee, was she
headed
alive when they took that
forward
No,
left.
she was
So
killed instantly.
picture? And Ginny, did you see Ginny that night?
Ginny was killed instantly also. She was right there on the road.
Again, on the left-hand side?
Yes,
And did you go by Bill Haspel?
Bill was on the right side. He kind of was thrown on the sidewalk.
Did you go by him at all, or?
Yes,
Objection.
I talked to him.
Hold on, there's been an objection.
Oh, I didn't hear him.
It's overruled.
it
And
could
her answer that she
I
gave
have
is-
no
I didn't need to
idea.
state the
It-
objection, but
it could just be a storage closet behind her.
Ma'am, I'm going to show you what's been
Or
previously marked.
we
and
haven't
admitted into
actually
evidence, which is
seen
Exhibit 15.
The
It's gonna
judge
show up
enter
on
the
your
courtroom.
screen,
That
okay?
could be where the judge enters
You
from her
Let me know
chambers.
when you see it in front of you. And I'd
Okay.
ask that be published to the jury as well. It's previously been admitted into evidence.
Go ahead.
Thank you. Ma'am, can you, is this look to be Main Street, the parade route from November 21st
His
of
notes haven't been helping
2021?
him.
objection, leading the witness.
It's
Sustained as
not.
to the form of the question, please rephrase.
Do you know what Exhibit 15 is?
We've seen this exhibit many
Um,
times. It has the list of
No, I
injuries
don't
and
know what this
fatalities along
really
the
is.
parade route.
Do you see, does it appear to be a map or something else?
Objection,
Pardon?
leading the witness.
Overruled, she may answer that.
Does it appear to be a map or something else?
Yes, where there's a lot of names and kind of a map.
Okay. Do you see a purple line on that map?
Yeah, with all the purple stars on.
Or I don't know if they're purple stars, but I see some yellow stars, some orange stars.
Yes.
Objection,
Yes.
leading the witness.
This has previously been marked and admitted into evidence. I think I can direct her attention to these items.
Agreed.
I think
Your
the,
objection is noted. It's overruled. This exhibit has previously been received.
I think the stars are, the color are pretty obvious what they are.
There's various color stars, and
It's
again,
only
the
two
exhibit's
color
been
stars.
received. The jury can determine for itself later on what colors they are and the meaning of them. But go ahead, you may ask.
Oh, yeah,
next
roll your
question of this
eyes.
witness.
And you see the street that, the long street that's depicted on Exhibit 15. Do you see a name on that street?
This lawyer isn't
Okay.
doing as good a
Do you
job
see
of
it?
laying the
Yes.
foundation
And what
for
is
this
it?
exhibit as the other two have.
I see all the stars. I don't know what the question.
Do you see a name on the street on the map?
Okay, let me see.
For
Main-
example, oh, go ahead.
Main Street,
For-
Broadway.
For a capital
So is-
case,
Main Street, the street that
The-
you were on when you were marching and your group got hit.
It's
I
just
believe
such
it
a
was.
big
Okay.
case.
Now, if you
that
go
it would be too
look
much
to
for
the
one or even two
bottom
lawyers
left,
to handle.
there is a box that's labeled Dancing Grannies. Do you
Yes.
see that?
And yes,
Yes.
Steve, this
And
is
it has
not playing
6
well with the jury.
names, 7 names in that box. Are those all part of the Dancing Grannies?
Objection, leading the witness.
Overruled. She may answer.
Grounds.
It's not leading.
She
I
may
That's the
answer.
grounds.
Go ahead.
And I'm
With
not surprised
the
Cruz has
exception
4.
of Bill,
It's such
he
a
was
huge case. I'm
Lola's
sure
husband.
they
Yes.
could have had
I'm
I'm sure he would
10.
appreciate that distinction that
kept
he was
them all
not
busy.
one of the dancers.
Right.
All of those people were associated with the Dancing Grannies,
Yes.
and the people in red are the ones that you testified are deceased as a result of being struck that day. Is that correct?
Yes.
And the other 3 that are in green are those people who were injured as a result of being struck that day?
Okay, 1, 2. Yes, Lola wasn't really injured. She just
Oh, come on.
was with Bill when he was injured
Okay.
to keep him calm.
Okay. And you see that there's a black line that
Well,
directs
that's a
it
not
to a
guilty on
yellow
one
star.
count.
Do you see that?
Unless they get
Yes,
someone else to
yes.
testify that Lola was injured.
Overruled. This exhibit has previously been received. It's fair for the state to direct the witness's attention to a particular part. And her answer may stand.
Does that appear to be the location where your group was struck?
Okay, yes.
It does?
It looks like it would be, yes.
Thank you. We can take that off the screen. I'd now like to show exhibit 55.
Getting through that exhibit was a bit painful.
Yes, just the witness. If we can play it for approximately, first of all, do you see it in front of your screen?
Yes.
Starting at 00, we're going to play it for approximately 10 seconds.
I'm assuming this will be
and then I'll ask you some
video
questions
of the
about it,
dancing
okay?
grannies being hit.
Thank you.
I've only
Does
seen,
that accurately depict
Uh,
what occurred?
I
to
think
your
all I've
group
seen of the
on
Cruz
November
trial is
21st,
when
2021?
the judge chastised his
I'm
lead
gonna,
attorney for
ask that it be
arresting
admitted into evidence.
the case
and
at the
published to the
beginning
jury.
of the
Objection.
day instead of the night before.
Overruled.
Grounds.
It's
But it did
relevant.
appear to be a funny shaped courtroom, so I don't know
Exhibit
how
55
it
is
was
received.
set up.
And Your Honor, this clip is 15 seconds long. I would ask that the full clip be played at this time.
And
Go ahead.
not everyone at the table is necessarily a lawyer, remember. Because there could be paralegals, legal assistants, technical people.
Ma'am, the group that you saw on the right-hand side of the screen, was that the Dancing Grannies?
Like here in
Yes,
the
it
Brooks
was.
trial,
And
you
did
see the 3
headlights
prosecutors,
coming through
and then
your
there's a
group?
table behind
No,
them
because it came from the back.
that I
I'm
think
sorry,
is
in
legal
the video,
assistants
did you
and
see headlights
Oh,
paralegals.
coming
yes.
through?
Objection, leading the witness.
Yes.
Overruled. She may answer.
And you answered,
Yes.
okay, thank you. And was that the path of travel you recalled
At least now
seeing
he
the red
has
vehicle take
3
as it went by you on
objections
the
he's
right
making.
and went through your group?
Yes.
I want to show it one more time for the jury so that they can now focus on the headlights on the vehicle.
Objection.
They're
Relevancy.
2 days
Please note that it's
behind.
overruled.
Grounds.
Permission to
Take
publish once
3
again
hours for the
Grounds.
tornado
is
warning.
granted.
And Your Honor, the
Add
state
it
is going
to
to
the-
pay 50%.
2
Grounds.
days behind.
Objection. Grounds.
That's about how
Noted.
much he's wasted.
Overruled.
Grounds.
Relevance.
If you can start,
And-
please.
Just shut up, Brooks. It's
I
relevant.
request legal reconsideration of your ruling.
No! Shut up!
Grounds of the denial.
Because it's improper. She doesn't have to give you grounds,
For the
especially
record,
in
may I
front of the
request a legal
jury.
or factual basis for your ruling?
Her failure to respond is a tacit agreement.
Is that a legal determination, Your Honor? Are you making a judicial determination?
You may continue, Attorney
Ma'am,
Basie.
did you see the body come forward and fly in front of the truck?
No, me being in
If
bed,
that were
in
the
video,
case,
did you see
this
the
jury
body
could cancel
Flying in
their
front of the
gym
truck.
It's
membership
not
No.
leading.
because they'd just
in the
be
video that you just saw?
marching.
You didn't see a body?
oh yeah, on the video, but not,
Right. And do you know who that was?
yes.
Who was that?
When they had it on TV, that was
No,
the man, right?
I'm sorry. Who was the body that went flying in the street that came towards the front of the screen?
Hold on 1 second. That last answer, I'm going to, because it was non-responsive, but I'm going to strike it, instruct the jury to disregard it. And then if you could state your question again.
Good job,
Sorry.
Judge. That
If we
was
can go
proper.
to Exhibit 55 again, to approximately the 10-second mark.
The witness doesn't understand they're talking to the
Yes, I am.
technical
Thank you.
person.
Can that be struck? The question,
It's been withdrawn.
can it be struck from the record?
It's been
That's
withdrawn.
May it be struck from the record?
There does not need to be struck. So the request is denied. It's been withdrawn.
May I ask for a legal and factual?
Remarks
basis
of
for
the
your ruling?
attorneys and questions
Jesus.
of the attorneys are not evidence. It's the answers that are evidence. So that's why it's not being struck. You may continue, Attorney Basie.
Thank you. Do you see a body probably in the middle of the screen on the left-hand side? On the ground?
Yes.
Do you know who that is?
Most of
Well,
what I
it's
see
hard to
from
tell who
Runkle
it's- but it,
is on
that
the
would
Friday Night
probably be
Frenzy on
Ginny.
Law and Lumber.
I'm now going to show you just you. It'll be in front of you on the screen, Exhibit 152. Exhibit 152 is 14 seconds in length. I'm going to show it to the witness, the entire 14 seconds, to see if she recognizes this. Do you recognize
I haven't
what's
watched
depicted in that video as
Natalie's
what occurred
coverage
and
just
what you
'cause
saw on November
by the time
21st
I'm
of
done
last year?
streaming, I'm done with it for the day.
Yes,
But I noticed that
but
she
when the
has been
car went,
covering it.
hit them, it was, it was
Just
on
everyone
my
in this
side.
Sort
and
of
I didn't
sphere
see them flying
Okay.
or anything.
of
I
sovereign
just-
citizen
But you saw
coverage
the
and
car
legal
come through, and
coverage.
You previously testified that you saw the car strike
The
them. You
world
didn't
has
see
stopped.
Where they went.
This is
That's
what's
Leaving the
happening.
witness.
Overruled. That answer may stand.
I'm going to ask that this be admitted into evidence and published to the jury.
Objection.
And
With
here-
relevancy.
Other than
The
Grounds for
objection's
other than
noted, it's
stating
overruled.
hearsay
and
or
Exhibit
relevance
152
or
is
the
received.
jury can hear
Permission to
that, but
publish
any
is granted.
argument
Grounds for your ruling,
is
Your Honor.
inappropriate in front of the jury.
Relevant.
I'm going to play it at full speed initially, and then I'm going to play it at 50%. So I will ask you questions after I play it full speed, okay?
And
Mhm.
demanding grounds from the judge on
With
every
some.
decision is just ridiculous, especially in front of the jury. And then he rolls his eyes and shakes his head and has histrionics and oh. We didn't see the video.
Ma'am,
You
who
could
did that
hear
vehicle strike,
you could hear the
in that
impact.
Exhibit 152.
Objection. Leading the witness saw the video. Saw
tomorrow
the video.
during-
Hold on, there's been an objection, everyone.
It's not
Um,
leading.
The objection is noted, it's overruled. Now you may answer the
Grounds for
question.
the overrule, Your Honor.
Because
It's overruled, you may
It's-
answer.
Grounds for the overrule, Your Honor.
Go
stop.
ahead, you may answer.
Tomorrow Duran.
Thank you. I'm now going to play it at 50% speed for the jury.
That was so hard to listen to. That makes sense, not being allowed to represent yourself in those kinds of cases. Because as we saw in the Trevor Summers trial,
And that
lots
was
of
the car that
times
you
people
saw
do that
traveling in
just
front of
to
you?
further abuse
Yes.
their
Objection.
victims.
Leading the witness.
Overruled.
Grounds for the overrule, Your Honor.
Because it's not leading.
It's overruled. Next
Grounds.
question.
Ma'am, I'm now going to, if I did not already do it, I'd ask that Exhibit 152 be admitted into evidence. I would then direct the witness's attention to Exhibit 153.
At the
which will show
next
just in
break,
front of
Judge
you.
Darrell
Okay.
needs to
Grounds.
admonish him to
Exhibit
stop with the
152
grounds
was received.
nonsense.
Already, no need to address the request for grounds by Mr. Brook due to that.
He's
The
just being
exhibit is
disruptive
in front
at
of
this
the court,
point, and
the
it needs
witness,
to
and the
stop.
parties, but not published.
Objection, I do not consent to or agree to being called that name, Your
Who
Honor, for the
cares?
record.
Go ahead, Attorney Basie.
Thank you. This clip
Would that be
is,
noted for the record, Your Honor?
Go
Shut
ahead,
up!
Attorney Basie.
Stop!
May that be
Stop
noted for the
interrupting!
Mr.
record,
Brooks,
Your Honor.
stop interrupting.
I just want to make
Mr.
sure.
Brooks.
Stop
Stop.
interrupting.
I just want to make sure it's on the record.
She told you to
Go
stop.
ahead, Attorney Basie.
I mean, at this point,
this
hold
clip is
him in
38
contempt.
seconds in length, Your Honor.
I
Again,
realize
I'm gonna
that
show you the
does
first
nothing
5
since
seconds
he's
of this clip and ask if it
he's never
accurately
going to see the
reflects your
outside of a
observations
jail
from,
cell.
November 21st
But hold
of
him
last
in
year.
contempt.
If you can start.
It's past time.
Ma'am, is that your group in the Waukesha Christmas Parade last November?
Yes.
Okay. I'd ask that Exhibit 153 be admitted into evidence and be published for the jury.
Objection, relevancy.
Exhibit 153 is received. It may be published to the jury. The objection is noted and overruled.
Grounds.
Ma'am, I'm going to have it played at full speed, and then I'll ask you some questions and then play it at half speed, okay?
Mhm.
Clear mics.
Oh. Oh. And you can see it on her face when she sees someone hit. Because we can't see it, but we could hear the thuds and see. It's reflected on her face.
Ma'am, what did you see in Exhibit 153?
Static.
that was just
It's
played
because
before
they
you?
think
I
unless
seen
you
Bill
say on the record,
being
for the
hit
record, let the record show.
And thrown
it doesn't
towards the
count.
Sidewalk.
That's Bill Hospital.
Yes.
And I'm going to show it now to you and the jury. Just a clip of it, starting at 0 seconds at 50% speed. What I'm going to be asking you about is where you are in this clip. Okay. So if you can start it. I see we may have a future granny in front of us here with the green hair.
Sure looks like it.
Objection, relevancy.
Your objections noted, sustained. The jury will strike that last question and answer. I mean, the jury will disregard that last answer.
Now, if you look at the street, pause. Sorry, keep going. If we can pause it now at 21 seconds. I would just ask, did you see after Bill Hospital was struck, did you see some feet coming through the screen on the bottom at the very end of that clip?
Objection,
I
relevancy.
seen him in the legs. Yeah.
Wait,
And then
wait
did you
to
see your
answer.
feet, Mark? That would have been the approximate area that he was hit. Did you see your feet in the video at the end? It's fine if you didn't. It's
Not
totally
really.
nice. Okay, thank you. Nothing further, thank you.
Ma'am, I'm going to
This
give
is for
Mr. Brooks an opportunity to
Cruz,
ask you questions
see?
as well. Please answer those for him. Go ahead, your cross.
This is going to be
During your
messy.
testimony, you kept referring to he. Who were you referring to when you said he?
you.
I can't understand him.
Can you please state your question a little bit louder? She was not able
Yeah.
to hear.
I apologize. I'm sorry.
You need to be closer to the microphone or project your voice, okay?
I got it.
Thank you.
During your testimony, you kept referring to a he. Like a lot of times you would say he. Who were you referring to by the he?
You,
Who did you mean by the he?
He,
Yes.
when it was showing Bill,
No, not
Bill
the,
would be the he.
that you're that was a vague question.
before today. Have you seen any of those videos before today?
No,
Well, that threw him off. He had 10 more questions to ask about
You
that.
stated that you saw a red vehicle strike the grannies. Do you remember if that was, or let me back up. Do you remember what type of vehicle you saw?
it was like an SUV. It wasn't just a car. It was, the flat back.
But she can't
I'm
identify
bad
it
for
as a
cars.
Ford Escape.
And all I know
Well,
is I
that-
seen
that
the
means
red
not
streak,
guilty.
and then all of a sudden, I seen the car in front of me.
So would you describe it as a car?
No, she said SUV. She said SUV.
It was a vehicle.
She already said SUV.
And how close did it come to you, if you recall?
I would say several feet. I was in front of the music vehicle, and it came around the music vehicle on the right side, and that's
So the
where
music
Bill
vehicle
and Tamara
saved her
were.
life by
And
being
I
a
was a
blocker
little
for
bit this
her.
way because I was directly behind the music vehicle.
Were you able to see into the vehicle in any way?
Was I able to what?
To see inside of the vehicle?
No, because it came behind me.
So you didn't get a look at the driver at all?
No, I don't have eyes in the back of my head.
Good answer. Good answer.
Do you recall what happened when people were struck by the vehicle?
They died.
No, I couldn't see them being struck from where I was. The vehicle was big, and it was after the vehicle went through our group that I seen all the people that were struck.
I hope so too.
Earlier,
Grip.
you testified to people being thrown to the side of the street. Would it be fair to say that?
No,
And I'm going off your last
none of
answer
this
to
is
the
fair
last
to
question.
say.
Would it be fair to say that you didn't see that with your own eyes?
No, that's where they were found.
But you didn't see it with your own eyes.
No, I couldn't.
But they didn't jump to the side of the street of their own accord.
You also stated that a few of the people that were struck died
Yep.
instantly. Would that be fair to
Gotta
say?
be unanimous
That
in
died
criminal
instantly.
trials.
You mean?
Yeah, you stated that a few people that were struck died instantly. Would that be fair to say?
Yeah, that's
Some
what
of
she
them,
said.
yeah.
And
2 were injured, and
how would you know for sure that they died instantly if you didn't see them struck?
Because they were dead by the time
Because-
she found them.
the police found 2 of them on the sidewalk, one on the left, one on the right. They were already dead.
So were you told by the police that they were dead?
That what?
Were you told by the police that they had passed away?
I could see they were working on them and weren't getting anywhere. They were trying to get the heart started with the heart machines.
God, I hate
Nothing
him.
was working.
And you know that for sure.
I seen them
They're
working on
dead.
it. Yes,
They're dead.
not
But-
all of them, but on some of them.
So was it fair to say at that time that you had no medical diagnosis at that
Jesus.
point in time?
Nobody gives nobody diagnosis. They just were working on them and trying to get them revived, but they couldn't do it.
So it would be
If
fair to
I
say at that
remembered it
time you
word
had
for
no
word,
knowledge
I'd give the Monty Python
of
dead
the
parrots
injuries sustained.
rant. They're
No.
dead. They've ceased to be. They've met their maker. They are ex people. They were dead.
You stated that I believe it was a Kathy. Did you know a Kathy that was part of your group?
Yes, 2 Cathys.
You stated, I don't remember which one,
Well, that's a you
but you
problem.
stated that one of the Cathys had a sister or something.
Yes, on the sidewalk watching the parade.
Do you
And she
recall
got
the
her the
sister's
hell
name?
out of there.
No,
Are you sure it was a sister or maybe just a relative?
How does this matter?
could have been a sister or a relative.
How does
I
it matter?
figured It was
She
a
got
sister.
her out of there.
So
She
it'd
was
be fair to say you
uninjured.
didn't know for sure who it was.
Who cares?
It was someone in the
Go
family.
ahead, you may answer.
Who cares?
Go ahead, you may
She
answer.
wasn't injured,
Okay, it was someone in her family,
and
that
her
was
family
trying
got
to
her out of there
console
because
her,
she was
but
traumatized.
she was just standing there out of control, weeping and
You stated that there was a music van of some sort.
our views a music vehicle.
Yeah, it was playing Jingle
And you
Bell
also
Rock
stated that
when we heard
you
it.
couldn't hear what was going on behind you because the music van. Would that be fair to say?
That's right. I didn't
So
hear
she
anything.
probably didn't
I
hear
just
any horns
seen
either.
A red streak when it came past me.
So would it be fair to say that if a vehicle was honking a horn, you wouldn't have heard it if it was behind you?
I don't know. No, there was no horns.
But you don't know for sure because you stated that the music was playing pretty
She
loud.
said she didn't hear horns.
That's for sure. But whether I would hear a horn or not, I don't know.
But she didn't hear horns. She can't speculate if she would have heard horns. She didn't hear horns. Not that it excuses you. I don't know how he thinks
Were you
honking
able to
his
see
horn helps him.
a license plates number of the vehicle?
License plate?
No. I was just shocked that a vehicle would be in the parade route. I didn't have time to read a license plate.
She thinks this is ridiculous a question as I do. Because it is ridiculous. He is ridiculous.
And you stated that there's also a member of your group named Lola.
Named what?
Lola.
Yeah,
Lola.
you killed
Yes,
her
it was
husband.
her husband, Bill.
And she, to your knowledge, to your recollection, Lola was not injured?
No,
See, that's the only good question he's asked. Because if there's a charge for Lola, this could actually be a not guilty on one count. Or however many counts are attributed to Lola.
You spoke with knowledge of a lot of the injuries. Would that be fair to say?
yes,
Have you yourself ever had any medical training of any kind?
no, my family is all in the medical field.
Have you yourself ever been
No.
in the medical field?
No.
Who cares? She didn't say she treated them.
Did you see anyone behind you struck?
She already
No,
said she
'cause I
doesn't
was
have
behind the
eyes on the
music
back of her
vehicle.
head.
I mean, in front of the music vehicle.
And you yourself weren't injured, right?
She already said.
No, The car couldn't get at me because they would have to go through the car.
She had a blocker. She had protection because you were avoiding cars, but not people. Which goes to show you didn't care
stated,
about hitting people. You just cared about
that-
keeping going.
You went inside of a building at some point, or one
Yes.
of the businesses,
Yes,
and you stated that you couldn't stay in there because you wanted to see how bad everything was outside. Would that be fair to say?
well, I was
This is
outside
this is
first,
dumb. This is
walking
dumb.
and seeing everybody, then watching them work on them. And the tavern was trying to comfort us by inviting us in for coffee or water, something to get us. But I couldn't stay in there. I had to be out there with them people.
Do you recall about how long you stayed in the tavern? I think you said it was before you
Yeah,
went back out.
I would say between 5 minutes and 10.
So when were you informed by I guess I would say medical personnel of the injuries to your group?
When I seen them working on them, they had the heart machine on Ginny, and blood was pouring out of her mouth, and I knew she was gone. There was no doubt about it.
At any time during the incident, did medical personnel come to you and
No.
tell you
They're
injuries?
dead.
No, just the
They're
police came
dead.
to me to know that where Lee was, because I was wondering where she was, and the police showed me her photo and said that she was.
I mean, the fact that
Gone.
she didn't treat them means that they're not dead, so not guilty. Case closed.
At one point in your earlier testimony, you pointed to the defendant table and said, "That's him from the news." Any reason
And that
why you would
was
say that?
struck. That was
From the
struck.
news.
Yeah, that's-
I didn't say that.
That was struck.
You testified that you
She
saw.
didn't
pointed to the
testify because that
defendant's
was
table
struck. You're bringing it in.
and said that's him from the news, and you were cut off right in mid sentence.
I wasn't saying that at all.
So, have you ever seen any news coverage of the incident?
From Lola, I knew that Bill had died during surgery that evening.
Okay, that's
And
non-responsive.
so I
but-
knew that from her because she was at the hospital with him. I knew about,
Ma'am, did you hear that question about seeing news reports, and just be a little more specific on the
I
time?
don't
Okay?
know what you
I'm
mean
trying.
about news reports.
Fair enough.
On the
Rephrase.
regular news or,
He'll rephrase.
okay.
At any time, do you recall seeing any news reports related to the incident? At any
It
time.
was on the news. Yes.
So it'd be fair to say that you watched reports of the incident.
And she
Well,
was
it
there
on the
too.
regular news in the evening.
Was it
They didn't cover much of it. They just showed that the dancing grannies, that.
would it be fair to say you learned additional information that you didn't have when you were at the incident from
Yeah.
the news?
Not from the news, I didn't know.
Okay.
I knew from the family.
So would it be fair to say
I
that
hope it's life in general population.
before you received information
See,
from the families, you
he's
weren't
he's
sure
going to be
of
popular in there.
the exact injuries to the grannies in your group?
Some of them I knew right away.
And
because of the police.
She was
did
there.
you know just from observation, or were you told?
I was
She
pretty
could
much
observe
told.
who was injured. She was told what the injuries were, but she could observe that people were injured. She was there. Exactly, Teresa. And good morning. He gets hung up on irrelevant points.
And from the videos that you saw here
but
today,
he's
which
like
you already stated it was your first time seeing any of those videos.
Yes.
he just latches onto something and can't let go.
Did you see anything in those videos today that you didn't see at the time of the incident?
Yeah, the people being hit and flying. Once the car was in front of me,
No, see, I
that's
want
when
plenty of inmate
it left the
contact
bodies behind.
for crews. I want the
But
contact.
you didn't actually see.
I couldn't. The
He-
car was in my way.
He's not going to be a popular person in prison.
And do you recall who else was not injured from your group besides Lola?
The four of us were not injured.
Do you recall the names of who was not injured?
The people
Kathy
that you
Z,
aren't
Cheryl
charged with
Millard,
injuring.
Me and Lola and Kathy. The other Kathy. There's two Kathys.
Both Kathys, to your knowledge, were not injured?
No, they weren't.
Were you charged with injuring either Kathy?
We were all that was left standing.
Do you recall about what time you left the parade after the incident?
What do you mean after the incident?
Do you recall what time you left?
What
Left
time
the
you
parade.
left? What time you left?
That was when everybody was taken away. And I think then we were
I
in the
wouldn't
bar
think to
having a
look at
cup
my
of
watch.
coffee. And then I had to find a way home because the music vehicle had to stay there because it was a crime scene. So Kathy Z's family took her home, so they gave me a ride right away too.
And you don't recall about what time that was?
No.
That would be fair with everything else going on.
That's the jury, at least during the trial, is supposed to be anonymous. That's why they're not showing them on camera. Are they in the cruise
At any
trial?
time in the days following the incident?
But like, if you think back to
did
the
you
Johnny
see
Depp
any
trial,
reports of
the
a suspect at any
the
time?
judge put a 1 year.
I seen it on the news that a suspect
basically
was
she sealed
taken
their identities for a
or
year,
found,
so the
I should
court
say.
won't release their identities, but the jurors themselves
And
are
what-
free
What are you
to come
referencing when you
forward
say
after
found?
the trial and say, yeah, I was the trial,
What
or
was
I
that
was the
one?
juror, come
found.
interview
In other
me.
words, the police found him.
But after the jury, or after the trial, it's up to the judge whether or not to keep them
or who he was
anonymous.
at the time.
And the jurors can always come forward after the trial and say, I was a juror. And that's probably fine. That's, there's probably 1,000
I don't recall
Benjamin
if
Thomases in
This question
Florida.
was asked, so I'm going to ask it. Were you there with any of your family members, immediate family or anything?
My
But
immediate family members,
they shouldn't
just
have
my husband,
probably shown the juror.
and he was driving the music vehicle.
But once again, it's not a hard and fast rule
was he injured in any way?
necessarily. Because, like, showing them on camera, if I were in the courtroom, I could see the jury,
Outside of
obviously.
being shocked by what
Well,
he was seeing.
And so,
physically.
of course,
physical injury.
her husband wasn't injured.
Did
She
he-
was
did
in
he
the
suffer
music
any-
He was
vehicle.
in the car.
You were avoiding vehicles. Exactly, Grip. It's annoying me,
Do
so
you
it's got to
recall
be
giving
annoying the
any,
jury. It's wasting their
police
time.
statement, or were you interviewed by any law enforcement
Yes.
after the incident?
Yes.
Do you recall if it was the same night of the incident or
Well, that
the
was
days following?
talented of me, spilling my
Both.
water.
Both?
Right there at the time. And then the next day,
Yeah, she helped them identify Lee by photo. Of course, she interacted with the police there.
Did you ever file any claims related to the incident?
I believe not of the incident, no, because I was there when they were talking.
She didn't understand
the
his question
gals that
because
were
what the
hurt.
hell is filing a claim?
They were like interviewing.
And why
us.
would she? She wasn't
The
injured.
four of you,
She can't.
correct? The four that
Suing you
one,
is
the two,
Yeah,
the
all
two
of us.
cats.
Yeah, the ones that
a
were
waste
left.
of time. That would be the kind of
Do
claim
you know if they
that
filed any claims
victims would
related
file.
to the incident?
Objection.
If
How would
what?
she know?
Do you know if they filed any claims related to
Objection.
the incident?
How
Grounds,
Cause for speculation.
grounds.
calls for
The
speculation.
ruling, yes, it is overruled. So you may answer if you know.
Okay.
Exactly, Darlene.
No, because we were all together and came to every
Sovereign citizen
interview
nonsense.
that they
It's
needed from
abusive.
us.
And how would she know if other people filed claims? She's not them. I mean, he could ask, did you see
you recall,
other grannies talking to the police on the scene? That's one
Seeing
thing.
or reading any complaints related to the incident?
Who?
Grounds.
It's
Sustained
irrelevant.
as to the form of the question. You don't have to answer that.
Okay.
Should I rephrase the question or?
You can try.
Sustained as to the form of the question.
At any time during any interviews with law enforcement, were you shown a complaint related to the incident?
Why would she
Grounds.
be?
Sustained as to the form of the question.
Were you informed that it may be a possibility that you might be called to testify in this?
No,
matter?
she just showed up randomly to
Um,
testify.
A lot later, not at the time.
we-
I had no idea of testimony until
would you
Every witness
would you
just showed
say
up
much
randomly.
later, as you say, would that refer to weeks, months?
months. I was in no shape at the time to testify or talk about anything.
She was traumatized.
Do you recall seeking to testify? Wanting to testify?
No, I didn't ask to. This just happened when we would be in our interviews with, and then,
So it would be fair to say that you were asked.
No,
Or
she was not
subpoena-
axed.
yes,
Do you recall by whom?
I imagine.
prosecutors.
DAs or
The Tooth Fairy asked her to testify. Or no, sorry. Paul Bunyan asked
When you say
her
the DAs,
to
do you mean the
testify.
district attorney's office?
yes,
Did they ever identify to you as being the plaintiff in this matter?
Objection.
Sustained. Next question.
Grounds for the sustain, Your Honor?
What the hell is sustain?
Relevance grounds.
Do you recall ever being told that there was a plaintiff in this matter?
Objection. Irrelevant.
No, it's
Calls for a
just,
legal
I
conclusion.
was interviewed a few times, the 5 of us. And that was
Shut
pretty
him
much
down.
the end of it.
Don't let
until
him abuse her.
months ago where
I think probably a little explanation is needed.
You need to ask
Are you
clear
aware
questions.
what a plaintiff is?
Objection relevance.
Grounds.
Sustained. Next question.
Grounds for the sustain, Your Honor?
Next question, Mr. Brooks.
Grounds for the sustain?
Because it's irrelevant.
Ask your next question.
It's a legal
I
conclusion.
I just want to know the grounds, just for the record, the grounds for the sustain.
The same grounds
Ask
that
your
the
next question.
prosecution gave. It was upheld.
Right
She
there.
sustained it. Shut up.
The grounds should be put on the record.
Ask your next question. I'll address this all at the next break outside the presence
Stop
of the jury. Ask your next
arguing.
question.
Your Honor, with all respect, I think the jury
Mr. Brooks, under
deserves.
90611, ask your next question, or I will determine that the
Exactly,
cross-examination is now
static.
closed.
As we
I'm
gonna-
determined
I'm gonna
yesterday.
keep going. I
By
just think the jury
substain,
deserves
he
to
means
hear
Mr. Brooks,
he's a
I'm
skid mark.
instructing you to stop making those statements. The jury will disregard. This is the cross-examination. It's not your opportunity.
They don't
to make
need to
legal
know.
arguments
You don't decide.
or to
what's
testify.
appropriate
You have an
for them to know or
opportunity if you
not.
So choose to do that later.
With all respect,
Next
that is not
question.
question. The jury just deserves to know.
All right, under 90611.
Thank you,
the
Judge.
Cross-examination
Thank
will
you.
be
have a question,
determined.
Your Honor.
Sir, you didn't follow my very clear instructions.
Thank
Does
you,
the state
Judge.
have any follow-up?
No, Your Honor.
All right, thank you, ma'am. You may
Objection-
step
Objection
down.
to that, Your Honor. I
Your
was
objection's
not-
noted. Ma'am, you
I
may
was
step
not-
down, and after
You-
she steps
you
down,
are
I will be
done.
excusing the jury for a few
You were
moments.
being abusive. You weren't
Please
asking
rise for the
questions.
witness
You were
and for
arguing.
The jury as they leave the courtroom.
I mean, he he's so ridiculous.
Mr.
Shut
Brooks,
up.
Please wait.
I'd say he's a petulant child, but that's an insult to petulant
You may
children.
have a seat, everyone.
He's awful.
To specifically address the repeated request by Mr. Brooks for the court to state the grounds, sir, I am not legally required to
Thank
do
you,
that.
Judge.
Those are legal determinations that if you feel there is an error later on, you can address on appeal if you are convicted. I have been answering many of them
But
at your
she doesn't have
request,
to
but I
answer
may not
any of
do
them.
that at all times. In fact, you're asking me to provide that explanation and really highlight for the jury the court's opinion on relevance. That's why we
Exactly.
don't state that. There's an
Exactly.
objection. It's a party makes it, states the grounds. Sometimes I ask the opposing party for their position. Sometimes I do not. Many times it's very self-evident. Either the objections are baseless. Many of the hearsay objections are baseless.
Wait,
Your objection to hearsay is it's not hearsay.
I,
So that's why
I have
to me
two
they're
words.
self-evident. I say
P.
sustained,
Barnes.
and we go forward. So you need
Not a
to
gavel. We need P.
be aware,
Barnes.
sir, that when you ask for the grounds, you're asking me to state a legal conclusion in front of the jury,
And that's
which I don't
inappropriate.
feel is necessary. for the reasons that I've already stated, that you're asking me to highlight my opinion on relevance and my determination on relevance. So going forward,
This is
you need to
relevant
be aware of
because
that.
how you hit
Again,
them with
not a
your
sign of
car
disrespect.
is
It's-
relevant.
The record is
I
self-evident. Many times, if I feel that more argument is needed, I'll excuse the jury. But I haven't felt the need to do that up until this point.
And that's so
And I
she
will
could
caution you once again, sir, 90611 is the
lecture you.
statute mode and order of interrogation and presentation controlled by the judge. The judge shall exercise reasonable control over the mode and order of interrogating witnesses and presenting evidence so as to do all of the following. A, make the interrogation and presentation effective for the ascertainment of the truth. B, avoid needless consumption of time. C, protect witnesses from
Exactly.
harassment or undue embarrassment.
And this was just harassment of the witness.
And it goes on.
That's
but
why
for
she ended it.
purposes of
He
what
was
I'm going
wasting
through, that's the
time.
most
He was
relevant
harassing
portion of 90611.
the witness.
So when I give you the warning that under
needed to
90611, I will cut off your cross-examination, it's because you're violating 90611.
And
So-
is that a judicial determination that I violated 90611?
Yes, that's why she stopped
Advising
you.
you, sir. It's not a specific determination as to anything that's happened thus far, just a summary of why I am relying upon 90611 throughout the
Every decision she makes is a
questioning of
judicial
witnesses and the
determination.
presentation of
The-
evidence.
I mean,
So with
This
that,
is
we're going to
ridiculous.
continue. I'm going to have the state be ready with their next witness.
Your Honor, I'm not interrupting you. I'm letting you make a clear record.
you are
Mr. Brooks, you
interrupting,
have actually interrupted me.
saying
If
I'm
you
not
go through the whole
interrupting as you're
citing
interrupting.
of 90611 without saying anything.
I'm not asking for the parties to make an argument under 90611. I'm
why-
It's
advising
her
you.
call.
Stop interrupting me, please,
The
I'm
judge did it
advising
sua
you,
sponte
sir,
on her own.
so that you have hopefully more
It's
knowledge
judicial
and awareness
control
as it
of
relates to the statute
testimony.
that I've cited dozens of times during this trial.
I'm well aware of what I'm citing, Your Honor.
No,
Well
you're
aware.
not.
All
You
right,
have
so-
no
And I'm just seeking
idea.
for the record to be clear. With all due respect, Your Honor,
Then why don't you show respect?
that's judicial misconduct because you're not
Oh,
allowing the jury who deserves
Judicial
to hear
misconduct.
certain aspects of testimony. Like I stated yesterday.
If it's not
under the
admissible,
Sixth
she
Amendment,
can't
I
let
have the right
them
to face
hear
my
it.
accuser, which means
No, you
that
do
I can
not. You have the right
question
to
about
confront the witnesses against you.
clearly
You don't
the
have the
plaintiff
right.
being the accuser. How come I can't question
Go
about,
read the Sixth
if
Amendment.
a witness may
You
know
do
or
not
have
understand
had
it.
any prior interactions or any conversations or anything of the sort with the plaintiff who has yet to show their face?
The plaintiff.
Also, I didn't even,
she's-
the reason why I was objecting the way I was is because I
It's
was trying
because
to
you
get
didn't
to
understand how to object
question of,
properly.
the witness
You
saying
have to
that
object
about
in
the
good
four
faith.
ladies in her group that were not injured. There's relevancy because with her stating on the record, clearly for the record, and for Your Honor, and for the court and for the jury, that these ladies were not injured in any way.
Were you
But
charged
yet
with
there's still
injuring them?
charges associated with these
So
ladies who
make
were
that
not
argument in your closing arguments.
injured. That should be dismissed.
Make
We are
make
not
that
at
in closing
point, sir.
arguments.
The charges I refer you to the preliminary jury instructions for first degree
But yeah,
recklessly
call it out.
endangering
Now-
safety
now-
and the elements or the elements they don't need
They'll
to
get someone
prove.
else
There's
from the
certain
dancing
elements.
grannies to come in and
And
say,
so,
yeah, Lola was
I'm not going to have a
injured.
debate with you over the law at this point. I've made my rulings as it relates to certain questions that you have asked and whether they're relevant, whether they're vague, whether they call for speculation or a whole host
Get the
of
giant shepherd
reasons
hook.
that
but
a
it needs to be
question can be
electrified.
objected
Cattle
to.
prod.
I'm not further going to address your position on
He's so aggravating.
May I request a
The-
legal reconsideration
No.
of the
Finish,
ruling,
sir.
Your
You
Honor?
interrupted me. I'm not done with what I was trying to say.
It was no way for me
You-
to know that because you paused. I'm sorry. I apologize.
Just because I paused doesn't mean I'm done.
But
So,
you paused for
Shut
quite a
up.
while, so I wasn't sure.
in
Shut
any event,
up.
sir, we're going to keep going. Any error you believe I've made, you can raise again on appeal if you are convicted, but we will proceed forward. Does the state have
I'm
their
not
next
trying to-
witness
You are
available?
trying.
Please do not interrupt. I'm
Shut
asking the
And
same
that's why
question.
that's why I was just
Mr.
quiet.
Brooks, you're interrupting. Stop. Does the state have
Keep coming in.
available
You're still
their next
interrupting.
witness?
We do, but could we please request a comfort break, Your Honor? I'm sorry, but we haven't gone about 2 hours now.
All right, that's
As long
fine.
as
We'll
they're out.
take a 15-minute break. That's fine.
Thank you.
You're welcome.
For the record, Your Honor.
Shut up. You're on
We
break.
haven't addressed subject
You're
matter.
now off the record.
Jurisdiction.
We are off the record.
he he doesn't have an off button. I mean, even after they go off the record, he can't stop. The jury's walking into the room. He can't stop. I mean, and as I pointed out yesterday, pull it up again. He tried yesterday to subpoena the state of Wisconsin. And when the judge said, you can't subpoena the state of Wisconsin because the state of Wisconsin isn't a person, it isn't a human, he said, well, then you're violating my Sixth Amendment right to face my accuser. The problem with that is the Sixth Amendment in full. I'm reading it off my phone. It's not on screen, sorry. In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial. Notice, this is public. This is very public. Speedy, it's 11 months, but I guarantee most of the delay was the defense. By an impartial jury of the state and district wherein the crime shall have been committed, which district shall have been previously ascertained by law, and to be informed of the nature and cause of the accusation. So that part, the nature and cause of the accusation, is the arraignment, the reading the charges, providing him with the indictment or the information, the charging document. And then here's the part that he's been getting wrong. To be confronted with the witnesses against him, to have compulsory process for obtaining witnesses in his favor, and to have assistance of counsel for his defense. So he has the right to be confronted with the witnesses against him. It doesn't say to confront his accuser. It's the witnesses against him, not accuser. There is a difference. So it's just ridiculous. So, and see, it's not just the state of Wisconsin. It's there are so many victims that they can't fit in the courtroom. Because so they've invoked the exclusionary rule. So witnesses are not supposed to be in the courtroom watching, but victims can, even if they are a witness, generally. So like the police officers have been excluded. This last witness, the dancing granny, she should have been excluded too, because she's not a victim. But people who he struck and who he's charged with striking, who are still alive, can be in the courtroom, but there's not enough room. Plus, they set aside a bench for the media. They set aside a bench for his family and supporters. So, other than that, they can fit what, 20 more people in the room? So, they actually have other rooms in the courthouse where they're broadcasting it, but even that probably isn't enough. So that's one of the reasons why this is being broadcast. And the thing is, like, we're not seeing all the videos and exhibits like they would in the courtroom. I think for the victims in the courthouse, I think they're even in the other room, if whether it's a conference room or a different courtroom or whatever. I think they're actually playing the whole exhibit like as if they're in the courtroom. I could be wrong, but it's just ugh. He he gets me so heated. But I'm going to run, have my morning 5-minute break. I'll be back shortly, and then basically this is me saying rant over. I'll be back in just a minute and fast forward to court resuming. So back in. All right, I'm back. I'm gonna fast forward now for make up some of the time. Okay,
So you have that. All right.
here we go.
Do you know what time we took our break?
And once again, it varies. Juror anonymity
All right, we
after
are
the trial
back on
really
the
just
record.
depends
That
on the
appearances
court
are as they were
on
before. State have.
a case by
their
case
next witness
basis
available?
on
Yes, Your
local rules.
All right, let's bring the jury back out.
So it wouldn't be inappropriate
Don't,
necessarily.
Consent to
Your consent is not
being
needed.
called by the name that this court chooses
Give
to
her a
identify
different
me
name.
by. I want to state for the record that I'm here as a third party intervener on
That's
special
not a thing.
appearance on behalf of my client.
I mean, if you don't consent
Can
to
that be noted for the
that
record?
name, should she
Noted this morning.
should she call
May
you
it be noted
Chuckles
again for the record, so
McCaffwit?
that we can keep the record clear and accurate.
The appearances are as they were this morning. They are no different. Bring the jury up.
And we have yet to address subject matter jurisdiction, Your Honor. I still haven't been shown any verified proof that
All rise.
this
That's
court
not
has
required.
subject matter
You
jurisdiction.
haven't proven they
And at
don't
this point,
have
may I request an
jurisdiction.
affidavit that you, Your Honor, have no bias, no conflict of
The-
interest, and no interest in the outcome of this case?
She
Mr.
doesn't
Brooks, the
have to
jury's
provide
coming
you
out.
with anything.
We'll address your legal issues later, if I deem them appropriate.
Judge, do you hold the full
Mr.
judicial
Brooks,
power
shut
of
up.
the state, or is this
Please,
the
shut up.
military
can you
power?
please take the jury out? Thank you.
I mean,
Do you hold the full
Mr. Brooks, just wait
jurisdiction?
till the jury's out. please.
hold him in
I
contempt.
ask that you show that respect.
Hold
I-
him
I
in
will.
contempt
I will.
Thank
now.
you.
It's meaningless, but hold him in contempt. It's getting to that point now, Steve. I mean the it's expected for him to be in the courtroom, but he just keeps getting worse and worse and worse. It's
Everyone else can be, you all
she
can be
needs
seated.
to
Mr.
send a
Brooks, just make your
message
statements. What do
somehow.
you want to advise the court today?
I want to first state again for the record that I do not identify by that name.
Then
nor
give
do
her
I
a
consent to
different
being called
name.
that name.
Give her a
Your
different
Honor,
name then.
With all respect, I'm merely asking you, do you have the full judicial power of the state, or is this
She's a
military
duly
power?
elected judge of the state of
I'm
Wisconsin.
sorry? I don't understand what you're asking me, sir.
I'm asking,
Oh, so he can say ask.
Now,
this
what legal basis
not
are you
act,
making
I'm
that
sorry.
request?
I'm asking for the record,
Oh, for the
is
record, you
this
mean?
a common law court or an admiralty court?
Oh, Jesus
What-
Christ.
What are we in here? And I'm requesting an affidavit,
The court's
that you,
not
Your
going to
Honor,
give you
have
an affidavit.
no bias, no conflict of interest, or no interest in the outcome of this case.
You have to
And the
come
reason
and
why
say,
I
I
wanna
think you
state
have a
this clearly
conflict
for the
for this
record.
reason.
Mainly is because of the bias that's been shown. I
The
have
bias
not
that's been
been
shown,
getting any
she has shown
certified
no
copies
bias.
of any requests that I've made.
It's
which
because
I
you're
was
not
told by this
entitled to
court
any of them.
Address inmate communication forms for anything that I may need. I've done that. I've complied with that.
But that doesn't mean you're
Every time I've needed
you're
something of the court
That-
pertaining to documents, I've done it the way the court has asked me.
but
And I've
that
always
doesn't mean
stated
that you
that I
are
wanted everything to be certified. I have yet
allowed to
even get
receive
that.
all these things, or that these things even
my
exist.
Court docket sheet was not a certified copy.
What the hell
When
is
I
a
asked
certified
Your Honor
copy of it?
of your oath of office, I asked for that to be certified. You stated
That's
for the
not a
record that you would
thing.
not give
It was
me
a verbal
a
oath of
certified copy of
office.
your oath of office, which you are required
No,
to
she's
show if
not.
I ask for it.
No, she's not.
I've brought up
Show the law.
my Sixth Amendment
Show the law.
constitutional right that has been pretty much discarded
No, it
And
hasn't. She ruled
that
on
is
it.
based on the fact that I have the
told
right
you
to
that you're
face my
wrong.
accuser, which would be the plaintiff, state of Wisconsin, in this matter. They have yet to show that a
He's
claim
Paul
is
Bunyan. He's a
is-
lumberjack. That's why
I mean,
he keeps axing.
a living human being can only make a claim. An entity cannot make a claim.
Who says?
I've
Who says?
requested
That sovereign
for the
citizen
complaint
nonsense.
to be provided.
So
The
Apple can't
complaint
sue
from November
Microsoft.
23 of
They're not living
2021.
human
The
beings.
amended complaint from November 29th of 2021. The second amended complaint from January 12 of this year, 2022. I have yet to see those.
They're
There
in
was
your
no
files.
record of a
Just
bond
because you can't find
in
them,
my
that's not
docket
discovery. That's
I'm asking. I
the
asked for
bond
that to
isn't
be
a
verified
thing.
by proof.
The
That hasn't
bond
been
isn't a
provided.
thing.
There's so many biases,
It's
clear
not bias.
biases,
You just don't
and
understand
questions
what's going on,
that are
and
not
you're
being
living
asked
in the land of make
based on
believe.
judicial
You're making
determinations made
up
by Your Honor.
bullshit.
You look at the discrepancies, and I think they're clear. I think at minimum I deserve for the subject matter jurisdiction to be verified and proven.
It doesn't.
I've
You
raised that
haven't.
issue numerous
You've
times,
raised
pretty
it. You
much every
haven't
day,
made
every
an
time
argument.
I come before your court, Your Honor. I
You need
address
to
that, and
show
it has
why
yet
the
to be
court
proven.
doesn't have
My
jurisdiction.
filings have been disregarded, even though they've been filed into the record, even though they've been time stamped. I haven't got the
It's
original
because
copies of
they're
any of them,
nonsense.
which I'm supposed to get.
Says you.
And as we sit here today, I'm still not even understanding the nature and cause of the charges.
can't
That
force
hasn't
you
even
to
been proven. Can that be
understand.
provided in any way? I'm basically sitting here confused because I don't understand
That's because
why these
you
proceedings
are a
are allowed to
moron.
continue when there's so many things that have not been provided. They
MORON.
haven't been provided
All
in my
caps.
discovery. They haven't been provided to me
You
by
are a moron
being brought to
who
my
bought
pile where I'm
into
housed in the jail.
sovereign citizen fantasy.
Without so much information, valid
It's
information
not valid.
to this matter. And I believe that it should be verified and it should be proven for the record. And if not, I move for this case to be dismissed for failure to appear by the
Willy
plaintiff
Wonka
and
clip.
failure to
You
state a
get
claim for which relief
nothing.
can be granted. Everything that I'm saying, it has merit and it has
No, it
validity.
doesn't. None of it does.
As we sit here today, I'm still being charged with charges that shouldn't even exist based on the testimony that we've heard for
Then
the last few
argue
days.
that in closing arguments.
There's so many things left to still be proven. The
The
prosecution
state is
team
still giving its
hasn't
case.
even proven that they're licensed to practice law in Wisconsin. They haven't proven,
they
are
don't
they
have
just
to prove that
bar
to
association members, or do they have state issued licenses? That has not been proven, which I've raised that issue
They don't
for the
have to
record.
prove
I'm not
that
even sure
to
if that
you.
was even recorded in the docket sheet. There's so many things, and Your Honor, you still haven't stated
Notice
for
she
the record
hasn't
if you
said
have
a
full
word.
judicial power of the
She's
state,
just
or is
letting
this
him get
military
all
power?
of this out, and then
That
she's
hasn't
going to
been proven.
say, "All right, that's nice. Bring the jury back."
Nothing has been proven. Not subject matter jurisdiction.
You haven't
Not
proven they
licenses
don't
to
have.
practice law. My Sixth Amendment right has been basically trampled over.
No, it hasn't.
No complaints have been shown.
It
Neither of the
has.
3 that I've requested, by the way that you told me to request them by inmate communication. Nothing is certified that I get copies of when
Exactly,
I clearly
Teresa.
asked for them to be
Hammurabi's code,
certified
eye for an eye,
and to
car
be
for
filed
a
into the
car.
record.
Put him in
It's
front of
to the
a
point
red
where
Ford
Your Honor,
Escape at 32 miles an hour.
recuse yourself from the presiding.
Why?
At this point,
Why?
if you're not going to abide by the oath that you swore,
So now, Kim Blandino, you need to recuse yourself
which was in your oath, correct?
because you're ruling against my
You
frivolous
swore
arguments,
to protect the Constitution of the United
and
States.
that's what she's doing.
You swore to protect we the people.
That's what
That
she's
is not
doing.
being done here. If
we the
every
people
valid
isn't
argument that I
just
raised
you.
is taken by the court
You
as a
say
sign of
it's valid.
disrespect or a sign
You
of
say
trying
it's
to
valid.
intentionally be disruptive or causing a problem when I'm merely seeking understanding because I don't understand.
She can't
I'm merely
force you
seeking
to understand,
why this
and it's
information
not
has
her
yet
job
to
to
be provided,
explain.
and we're this far
Hire
into
a
this matter.
lawyer if you want someone to
And there's
explain it
still
to
no
you.
verified proof. Even as I sit now saying this, there's still no proof being provided.
Go hire a lawyer.
Zero.
They can explain it to you.
How is
She
this case
can't.
allowed to continue without these documents and filings being verified?
Because they're nonsense.
Is there any legal factual basis that can state why this information has not been provided? Why the docket sheet is incorrect?
Exactly.
Why there's so much on the docket
Everyone
sheet that
should just
be
be on
record
his
that's
side.
not even in there?
What's
That if we had the recordings of the record, they would see was brought up numerous times that doesn't even show up. I'm just asking for Your Honor to be fair,
she is being
which
fair.
is another
She's
right
been
that I
more
have,
than
the right to
fair.
a fair trial
She
and the
has
right to an
given you
impartial jury.
so much leeway. She has given you so much help.
I can go on and on and
unfair
on
to the
about
state.
what's not being done. I have, again, I say I have the right to face my accuser. Where's the injured party?
Show us
who's making the claim.
Who's the injured
I asked
party?
Your Honor
Start
numerous
with the
times
6
for Your
people
Honor's
you
name.
killed.
You wouldn't answer. I asked, did you have a claim against me? You did not answer. I asked the whole courtroom, did anyone have a claim against me?
She would have
No one
hung,
said
drawn,
anything.
and quartered me if I had done
Which you
half
stated
of
for the
this.
record, a non-responsive answer. A non-responsive answer is an agreement,
She's letting him
which
go
would be a
on
tactic
because
agreement by you, Your Honor, that you don't have to answer these questions that you should be answering.
say no to all of this at once
I have that right.
and then be done with it and
the
say,
plaintiff in
I've
this
already
matter,
ruled, shut
which
up.
was stated by witnesses in testimony to be the state of Wisconsin. But when I asked, do they see the state of Wisconsin present in the
they're
courtroom,
dead, and so it's
the question
their
is shut
estate
down, which
suing
is
on their
a valid
behalf.
question. The
And
plaintiff
so
should be present in this matter. Where is the plaintiff? Who's bringing the claim?
I mean, seriously,
Because we know an entity can't bring a claim.
Apple's an entity.
It has to be a living, breathing
Tim
human
Cook
being.
represents
No
Apple.
one is stated for the record if they're the injured party.
Don't.
Not Your Honor, not the prosecutors, not anyone in the court has stated to be an injured party in this matter. No one.
They've
Not
come
one
forward.
person.
They have said, yes, I was injured. Yes, my son was injured.
I have
yes,
the
my
right to
daughter
demand
was
that the
injured.
court place in the evidence any unrevealed contract.
Number one, the court doesn't place anything into evidence, and there
Has
is
that
no
been
contract.
provided to me?
This
Has that been
isn't
placed
a
in the
civil
evidence?
case. This is
I would
criminal.
like to see it.
Contracts are irrelevant.
Which is my right.
There is no contract.
I have the right to inform the jury about the truth in their duty, in their rights. That's the First Amendment and the Sixth Amendment.
You are duty.
But I'm repeatedly told to shut the question down when this is valuable information that the jury should be privileged to know. They deserve to know.
No, they don't. It's
once
irrelevant.
They were chosen,
they don't need to know
sit
irrelevant
on this
evidence.
Jury,
it's not evidence anyway.
Why are we keeping information away from them that they deserve to know?
Go read the rules of evidence. It shows you what the jury is allowed to know.
They decide the matter.
But the judge decides on the law,
valuable information from their knowledge. That's a disservice to the jury.
Is law. It's enacted by the Wisconsin legislature.
They're not allowed to hear
governor.
things that they should know, that they should be informed of.
The judge decides the law. What comes in as evidence is
inform
a matter
them of everything that they have the power to know, to do, and to know. They deserve that much. It would be a travesty for them to make a decision without being fully informed.
A travesty. You know what's
these
a travesty?
Are all valid
running
things.
Your car through a parade and
I have the right to
killing
protest
6 people
and object
and then injuring dozens
if
of
any
others.
of my rights
That's
or demands are not being met. I've done that numerous times, only to be shut down.
It's because it's frivolous.
Numerous times. I've raised the issues that I didn't consent to anything
Who cares? Your consent
that
is
may have
not
been suggested on
required.
behalf of my former attorneys. I've never even
So
consented to them making a plea
so
on my behalf.
what your former attorneys
I haven't,
did?
as a matter of fact, when it
just-
comes to a
just
plea, I haven't
throw
even
out all the
had
motions in
the
limine,
opportunity to
motions to
entertain any
exclude.
plea that may have been
Let the
suggested by the
prosecution bring
prosecution.
all of the
we haven't even
evidence
talked
in
about
that
that.
they've been told not to. You object to what your
Not
former
one
attorneys
time was
did?
it ever brought to my attention that the prosecution even wanted to offer a plea.
Well,
That's another
they
issue.
probably didn't offer you a plea agreement.
I have the
You're
right
not
to challenge the
entitled
jurisdiction
to
of
a
this
plea
court,
agreement.
which I've done numerous times.
You can plead guilty
I have the right to demand that the code be
and let the
construed
court
in
decide.
harmony with the common law. I just raised that.
The prosecution probably
I'm constantly
didn't
referred
give
to
you,
as pro
you a
se
plea
when
offer.
I've raised the issue that I'm pro per. I have the right to conduct my defense pro per, free from professional restrictions
Pro
imposed
per pro
upon
se,
licensed
it's the
attorneys,
same
which this
damn
court is well
thing.
aware that I am not a licensed attorney.
No.
In fact, the court is also aware that I only had 3 days
No. That's your
to
fault.
prepare for a trial that the prosecution has been prepared for a whole year.
That is your fault.
We see these
You
boxes
were
right
warned.
here. This box
She
alone
advised
is
you that it was a
45 or
bad
50
idea to
pounds
fire
full of
your attorneys. This is your fault.
so much information. I haven't even gone through half of it.
That's
It was stated for the
your
record
problem.
that the discovery, in its entirety, was brung to my housing unit on the 29th of September, which trial was scheduled. That would be a Thursday, which trial was scheduled for Monday.
And that's
How can I possibly
your
go through all
decision.
that?
You decided to fire
paperwork,
your
all
attorneys. The
the,
judge told you
digital
we can't
discovery,
postpone the
and
trial.
things of that nature. How can I go
We're
through
going
all
forward,
of that
and you
be
said,
prepared in 3 days?
okay.
That's a clear bias. I did not
It's
have
not
time
bias.
to prepare for this.
It's
Everything
your
I'm doing
decision.
is off the top of my head,
It's your
winging it,
fault.
taking it as it comes. When the court is well aware that I was not prepared, I raised the issue that it should be an adjournment. At least,
It doesn't matter if you're prepared or
at
not.
the minimum, it should be an adjournment because of that fact.
No,
at
she
least
told
to let
you.
me go through all the
She
discovery.
told you. You were
That was
warned.
denied.
You were warned.
No
You
valid
should've-
reason was stated for
you
that.
should have
when
kept your
Honor knew
attorneys.
there is no possible way, humanly possible, that I could be ready for a trial.
It's
of
okay
this
because you're not
magnitude
human.
in
You
3
have
days.
no humanity.
That's clear bias.
It's not bias.
I have the right to face the injured party claiming damages. That's under Article 3 and the 6th Amendment. I raised that issue again.
The
Where's
right
the injured
to
party?
face the injured party claiming damages.
Is the
that-
injured party present in court right now? Can anyone make a claim against me? Can you make a claim against me, Your Honor?
Are you fucking serious?
Do you know of anyone that can make a claim against me, Your Honor? Can anyone right now in court, anyone, make a claim against me?
The people in the gallery who are your victims.
And because of that, Your Honor, the motion to dismiss should be granted based on that alone. There's no injured party in this matter.
Yes, there is. There's 6
So who makes the
dead
claim?
parties.
Who? I have the right to put the judge on notice of my intent to appeal.
Who
And
cares?
any ruling
You don't-
decisions during
Just
the case.
appeal. Just appeal.
You stated for the record that I would have to wait until appealing process, but it's
Just appeal.
my right is that I can raise that issue during the case, which I've attempted to do.
And she doesn't have to
That's
stay
been
the
shut
case to give you time to appeal. Exactly, Static. I think prison's too good for him. He needs
I have the
exile.
right to
He needs to be
specifically
dropped
reserve all
on
of
a
my rights,
raft
which I
in
do
the
at
middle of the
beginning.
Pacific. Done.
I have the right to say what I want and to be heard under the First Amendment.
Generally, the appeals
when I
court does
attempt to do
have to
that,
let you in. The
it's taken
Supreme
as
Court is
A
a
slight to the court, a
permissive
disrespect to the court, or me intentionally
appeals
coming
process.
into the
The
court to be
Intermediate Court of
disrespectful, which I
Appeals
stated that is
has to
not
take
my
your
intention.
case generally,
never is it
but
my
they can
intention.
chuck it real fast.
I never intend to walk into your courtroom, Your Honor, and be disrespectful intentionally.
Then why are
I never
you?
come into this courtroom to disrespect
Then why
anyone.
are you disrespectful?
But because I don't understand, I raise these issues because they have validity.
No, they do not. They are sovereign citizen fairy tales.
I have the right to object to any statement made by the judge or the prosecution. I've done that.
Says who?
And been repeatedly shut down.
Says who? Who says you can object to any statement by the judge?
Without a lawful explanation. I've repeatedly asked the court for a motion for a finding of
True.
fact to determine
Whereas
if
the
things are
Supreme
being
Court can just
done legally. I've been denied that.
not even look
numerous
at that.
times.
You have to ask for permission to appeal
Without
to the
merit.
Supreme Courts generally. That's what I
which is
meant.
also my right.
You
I have
say
the right
it's
to
your
recuse
right.
the judge
No, you don't.
at any time,
No, you don't.
which is also a right.
No, it is not.
I have the right to a speedy and fair trial by impartial jury.
What you're getting.
I think it's safe to say that my speedy trial right has definitely been violated.
Says who?
Because this matter has been taking place for roughly a year.
And the
I've never
delays
consented to
were not
waiving
inappropriate.
anything related to a speedy trial.
You never
And
brought
if
up
that
speedy
was done, it
trial
was
until
done
you
without my
fired your
consent or
attorneys.
without my knowledge.
Well, then you should have told them to
We're way
invoke
past
speedy
the speedy trial date. Way past.
That doesn't matter if it wasn't
When the,
invoked.
change of venue motion was brought up. I believe that was the first time I came before Your Honor in early March. I want to say March 11th of this year.
Then appeal on that.
When
That's
change of venue
something
motion
to
came into
appeal.
play.
It's
was
not something you
decided
bring
by
up
Your Honor
now.
that wouldn't be decided until the 20th of June, I believe.
Exactly.
That's
asking for
that's
all
over
the mental
90-day mark
examinations
right
and
there for a speedy trial.
working towards a not guilty by reason of insanity,
That was
incompetence. That all
denied
takes time, and that waives
I
speedy
still don't
trial.
understand how that was denied when it's clearly obvious. that
Clearly
At
obvious.
minimum, the venue should have been changed
Can
based
you
on the fact of the
provide the
magnitude
case
of the
law,
matter.
the factual basis for that?
There's no
Just
possible
saying
way
it's clearly
anyone in this county would not have some type of connection or some type of
she's going to rule on all of this at
knowledge,
once,
whether
and
they
then
were
she going forward, she's going to say,
told
"I've
something
ruled
by
on
someone
this.
that they may
Be
know.
quiet, or you're going to be out."
The news reporting alone, just that alone, there's no way that this trial should be taking place.
Says
Waukesha
you.
County.
Says you.
That's obvious. That's
It's
from
obvious.
The way the motion was presented, the coverage alone, the political campaign ads that plastered the defendant's face all over the TV every single day. Every time a political campaign was brought up, it made reference to this incident. Every single time. The fact that people have children that go to the same schools in this county, that people may have worked with the same people in this county. You yourself, Your Honor, stated that you at one time worked with the father of one of the people that was injured in this matter. That is a clear conflict.
No, it's not.
Of interest right there. You also stated for the record that not only did you work,
show us the case law
with this father, but that at one time they may have donated to your, I don't know if it was to you becoming a judge or
people
I would have
donate to
the
campaign
docket,
funds.
But you said it on the record that they donated money to a cause of yours. You also stated that when you had gained knowledge of the incident and that their family member was injured in the incident, that you reached out via phone.
Have you been able to show any
I don't
bias?
recall if it was
she has
text
bent over
message
backwards
or
to
an actual
accommodate
phone
you.
conversation, but you put that on the record. You also stated that the nature of your relationship was strictly professional. I don't know about you, Your Honor, but I've worked numerous jobs, and I know what professional relationships is and personal relationships.
You don't know
I've never
anything
had
about
the
professional.
cell phone number of anyone that was a personal relationship saved to my phone that I can reach out immediately when I learn something. That would constitute a personal relationship of some kind.
Can you provide
Whether
case law
whether
for
hanging
that?
out from time to time, having a cup of coffee, or hanging out time for time, grabbing a beer, or hanging out from time to time, watching a game, or anything of that nature, it would definitely be more than just strictly professional. That was stated for the record. Again, I go back to the Sixth Amendment again
So you're being repetitive.
in terms of when I asked for the
When you
motion
asked.
for the evidence motion that I raised. That was denied without any explanation. That would be strictly to place in the evidence any unrevealed contract. That's under the Sixth Amendment. Clearly, there's been
Nice find, C.
repeated violations of my Sixth Amendment.
Show us.
We all know that the United States Constitution is the law of the land, period. It trumps everything.
Does it?
We also know that any law repugnant of the Constitution is null and void.
Well,
We know that.
And what law is repugnant to the Constitution?
There's still no basis for the motions being shot down.
There is. It's
Why
because
was
they're frivolous.
I not granted the motion for finding a fact? Why did it take so long for me to be brought my entire motion for discovery?
Your judge, your attorneys
Why
had
was
the
the motion to
discovery.
prove jurisdiction not verified? Why was the motion to dismiss the case for all the reasons I said not being granted?
Because it was frivolous. It was not brought in good faith.
Which brings me to the
You're
motion to
making
subpoena
stuff
witnesses.
up.
I did everything that was asked of me by the
No.
court pertaining to those subpoenas.
The court didn't ask
It
you
was
to do
understood
anything.
by the court that this is my first time ever having to do this. I didn't understand how to properly fill out the subpoenas.
The jury is
at which
so
the
furious
prosecution
right now.
volunteered that they would give assistance.
Which they don't have to do.
The only assistance
The
I received was
prosecution
for
doesn't
them
have
check
to give you
see if it was
assistance.
filled out right.
They don't have to
That
give you
was it.
assistance.
That doesn't amount to any assistance. I was still left to fill it out on my own, and then when I did that, correction still had to be made, which would verify
The
what I was saying.
prosecution doesn't
I don't
owe
know
you
how to do
assistance.
this.
They're the adversary. They're going
But I
above
still
and
complied
beyond.
to what
It's
the
not
court
their job
asked
to
of
help
me.
you. It
And
was
even
your
then,
lawyer's job.
It
You
was a big old
fired
thing
them.
about the subpoenas. I can't subpoena the plaintiff in the case. Well, how can I not subpoena the plaintiff in the case when under the Sixth Amendment I have the right to face my
No,
accuser,
you
which is the
don't.
plaintiff of the case?
No, you do not. You have the right to be confronted
So
by the witnesses
could,
against you.
how could the subpoena not be filed? And how could the plaintiff not be called to the witness stand?
Call the governor. That
begs the
subpoena would be
question of,
quashed
does
real
the plaintiff
quick.
even exist?
But call the governor.
Which it was stated for the record that not only by a witness, a detective Casey, that got on the stand and said on the record that is an entity, which is not a living, breathing human being. And then it was stated again by you on the record, Your Honor, that the plaintiff is an entity. So the question
No,
still
she
stands.
shut that
How
down
can
first thing
an
yesterday
entity
morning.
bring a claim if it's not a living human being?
And that's what they said. They said the state of
So where's the
Wisconsin
claim?
isn't a human. You can't subpoena the state of Wisconsin. Done.
Will the plaintiff in this matter, the state of Wisconsin, be allowed to testify? Will they be allowed to be in the courtroom?
She's already told you.
No, they will not, because they don't exist. Therefore, the claim doesn't exist.
It would be.
For
I
all
mean,
those reasons
the court
that I
would
just stated, the
probably
case should have been dismissed a long time
quash
ago.
it immediately. The
Once
prosecution
those
would
issues
say,
were
"This
raised,
isn't a factual witness.
this
The
case should
governor
have been
wasn't
dismissed.
there," and it would probably be quashed right there
And
and
at the
then.
very minimum, it
If
should have
it
been
reached the
dismissed,
governor,
because those still have
the
yet to be
attorney
proven.
general
You're
or
still
the
talking
governor's
about
council or whatever would
jurisdiction.
wouldn't even appear. They'd just file a response to
That's
quash.
been being asked for over a week.
It's been axed for over a week, and the judge has ruled she has jurisdiction. You bring it up
There's
over and
still
over and
no-
over,
no
but she's
providing
ruled
of
she has jurisdiction. You
license
haven't
to practice
provided
law yet.
evidence to the contrary. The judge doesn't have to show
Not
you
even by you, Your Honor.
anything. The prosecutions don't have to show you that they have the license to practice law. They've
Why was
shown
I
the
not
court,
provided with a certified copy of your oath of office?
because that's not a thing.
Why would you not state the name that is on file with the Secretary of the State? Or I made reference the first time to the Secretary of the Treasury, and then you
It's the Secretary of the
stated on the record that
Treasury.
it's the Secretary of State, even though you knew what I was referring to when I asked. You referred to your name tag,
I mean, this wouldn't be executive privilege,
but
but
that's not the
it-
name registered. We both know that.
it's
So why
just
wasn't
he
that
has
proof
he
verified?
has no personal knowledge, so he wouldn't be a proper
gave me,
witness. I'm sure
uh,
people subpoena the governor or the president or
A
the
copy
attorney
of the oath of
general
office, but it's
all the
not
time.
certified. So how can I verify that that is the true
She doesn't
oath of
have to
office that
provide you with anything.
you signed?
It's not
How
the
can I
court's
verify
job
that
to
that
answer
is
questions.
valid? That's the reason why I asked.
You
for it to be
deciding whether
certified,
things
which you
are
stated
valid
for
or
the
not
record you will
is
not do that.
irrelevant.
You never stated any
The court knows that she's a judge.
legal reason why.
She doesn't have to.
I have the right to ask for that.
And she doesn't have
legally.
the obligation to provide that.
I also have the right to call any witnesses to
No, you
assist my
don't.
defense,
No, you do not.
which is the main reason why I subpoenaed the
Wit-
plaintiff in
the,
this
the
matter.
key word, witnesses. Witnesses. You can only call witnesses.
I also have the right to challenge all relevant laws in this trial in terms of their intent, interpretation, fairness, enforcement, and whether they serve and protect the people.
Where's that from? Who says? Who says you can
From
challenge
my
the laws?
knowledge, the design of the statutes of the law was
Of the
written
statues.
for the common people to understand. So that would mean the final determination or interpretation of what the law says comes down to the people.
No, it does not. That is the stupidest argument.
You know this, Your Honor.
No, she doesn't,
Are
because
you
you're
not a
making this
public
up.
servant?
Are you done?
You also know
He's making up bullshit, but she's supposed to know it.
that this docket sheet is inaccurate. Every filing up until the point that I started representing myself was filed in a name that was represented by all capital letters, which is not my name.
Oh, Jesus Christ.
Nor has it ever been my name, nor have I ever seen that name or individual. Every single filing or paperwork was all in capital letters. Ever since September 29th, roughly around there, now everything starts to go to lowercase letters. Why is that?
We should have been playing
What
bingo.
prompted the sudden change?
He He's filling out the entire sovereign citizen bingo card in this rant.
I still have filings that have all capital letters.
Who cares?
Which
That's
I state
not a
every
thing.
time I come into your
This
courtroom,
is
Your Honor,
make
that is
believe.
not my name.
This is
Nor
make
do I
believe.
consent or agree to being called that name. I'm merely here as a third party intervener.
Which is not
On
a
behalf
thing
of
in
my
criminal law. It's made up.
Did I accept for value in return for value? We go through this every time I.
You
time I
go
come
through it. You go
Every
through
time.
it. And she rolls her eyes. Because this is not a thing.
You bring up
You bringed up.
Illinois versus Allen.
Oh, so it's not
when we had
Illinois
the issue
versus
of me
Allen
being removed
anymore?
from the courtroom. We went through that where Illinois versus Allen states that there are 3 options when a defendant is being disruptive in court.
And she
You stated
went
for the
with one
record
of the
that
options.
You identified a 4th one, which is not cited anywhere in that case.
The option she chose was less
It's
restrictive.
not cited anywhere. So the question would be,
The,
how did you come
the
up
fourth
with a fourth
option she
option
went
that's
with
not
was
written
putting him in a
that
different
case?
courtroom
Did
with
you
a
take it
video
upon
feed.
yourself to add
She could
this
have
fourth
just
option
removed
to
him.
justify
She could have just removed him according to Illinois versus Allen.
denying me
She
my
went with a
constitutional
less
right by being present?
restrictive option.
You could have done the 3 that were stated. Any
She
one
could
of the
have
3 you
gagged
could have
you.
done that were stated
She could have
in the
gagged you.
case.
She could have removed
Nowhere
you
does it say
to
you
your
can create
cell.
a 4th option.
It doesn't say she can't.
Not upholding my
It doesn't
constitutional
say
rights.
she can't.
I'm sure you know about Title 18, USCS 2381,
What the hell's 2381?
which states that it's treason
Oh, treason.
not to uphold your oath of office.
Treason.
Treason. You repeatedly make judicial determinations
That's what.
in my defense.
No, you think it
And
prejudices
then when I
your
question you
defense.
about are you making judicial determinations, I'm repeatedly shut down.
Because she doesn't have to answer you. I wish I would have looked at the time when this started. I didn't expect it to go this long.
Which leads to today.
Oh, it leads to today. All roads lead to
The
today.
constant push
The road through the parade
not
leads
to
through to today.
have an informed jury.
The jury doesn't need to be informed. They need to be
Not
impartial.
giving legal, valid grounds on objections. Not noting objections for the record.
She
to
is
make sure that the
noting
record is clear.
objections.
I'm sure somewhere in the jury instructions, you informed them that the state of Wisconsin was bringing the claim.
Go read the jury instructions. You have them.
But then you make the judicial determination that I'm not allowed to ask questions about the plaintiff. That's clear bias.
No, it is not. And I love how
And it
she hasn't
prejudices-
said a
it
word. She's not
prejudices
responding
my
to
defense.
any of this. But not letting
You
him
know
go through
also that
sovereign citizen
you have
BS
the
in front of the
electronic
jury
filing
is
system.
not bias.
I find it hard to believe that I was told yesterday about my subpoena for the plaintiff that I had to wait for a filing in a timestamp when I've seen it done numerous times in just a few
Attorneys have access to the
Right in front of
electronic
my face.
filing
seconds.
system.
When the prosecution needs
You
something
don't.
filed, it's filed immediately.
That's because they're lawyers. Your lawyers would have been able to. You're
I
not a
have to wait,
lawyer.
or I have to wait till the next day.
You're not a lawyer.
That's a clear bias and a clear prejudice to my defense. obviously the court knows that I'm not privileged to the same.
Exactly. They are part of the
filing
executive
system.
branch, the district attorneys. And so they are representing, even though they're county
Which
attorneys,
brings me to the reason
that's
why
a subdivision of the state of Wisconsin. They are representing the
I
state
brought
of
up the issue
Wisconsin.
of assistance of counsel.
That's made up sovereign citizen gobbledygook.
Under the Sixth Amendment, I have the right to assistance of counsel. It doesn't say anything about
Lawyers. You
representing yourself without assistance of counsel. Having counsel represent you and having assistance of counsel is two totally different things.
Yeah, and one of those is made up.
You, Your Honor, gave me paperwork that was a waiver of counsel. We both know.
In fact, two
that
branches of government are in the courtroom because there's the
any
judicial
contract can
branch
be altered
and there's the executive branch. The legislative branch isn't
if I
there
don't agree to
because
certain terms.
they can't make laws about what's going on.
I
'cause
crossed out
that would be
everything
a
in that
ex post
paperwork that I
facto
did
law.
not agree or consent to, and specifically wrote on that paperwork that I do not waive my right to assistance of counsel.
You
At
fired
the
your
very least, I
lawyers.
should have been awarded a standby counsel, not someone to represent me, to speak for me, but someone to
In
help
the
me
state
do
of
things in a
Wisconsin,
timely
you're not
fashion.
entitled to that.
Get things filed in a timely fashion.
You were
Get
warned.
motions together in a
You were
timely fashion.
warned. Go hire an attorney.
Make preparations to get things done that I don't have the privilege to do in my current situation of being housed at the Waukesha County Jail.
You object to being in jail.
I gave you back that paperwork and you accepted the paperwork that I altered,
She didn't.
that you understood that I didn't
Oh,
agree
she
and consent to those
understood.
things that were altered.
She
You accepted
understood.
it and you filed it.
That doesn't mean
That is
anything.
in the record.
That doesn't
I
mean
have copies
anything.
of the same paperwork that you accepted.
That doesn't mean
So
anything.
when you accepted that with no objection,
She doesn't object.
that becomes a tacit agreement.
She's not a party. And failure to agree,
But yet,
failure
I'm
to
still forced
respond
come in
isn't
here
agreement. And what's a tacit
with
agreement?
zero help. I think it's clear
You think.
that prejudiced my defense,
You think.
knowing that the prosecution has everything that they need for this matter at their fingertips.
And your
And
lawyers did
I have to
too.
jump
You
through every
fired
hoop
them.
possible to even get things filed in a timely
You
fashion.
were warned. They told you. You said, okay, I
It was
still
stated
want
for the
to fire
record
my
that
attorneys.
the unit that I'm housed in the Waukesha County Jail, and per jail administrator Angela Wallenhoff, that I'm only allowed out of my cell for a few hours a day. So I'm roughly locked down 22 hours a day.
But they also said
Not
you
given
have
the
access
privilege to access
to-
everything that I
to a
should be able
tablet.
to
You have access
at the time that I
to
should be
your materials.
if I was general population. Arrangements could have been made months ago.
But you didn't fire your attorneys
me to
months
be
ago. You fired them on the eve of
At least in some
trial.
form,
That's
general
your
population
fault.
with an upcoming trial.
It's your fault.
Reference was made
You
to
were
being able to
warned.
use LexisNexis or whatever it's called. We call it the law library. And
Oh,
maybe
it's the law
the
library.
easier way to describe it. I'm only allowed to access the law library at certain times during the day. The rule of the jail is that when you're not in the day room,
It's not like
you
this
can't
matters
access
anyways, because it's
the
past
law
time to
library,
be
which is on
filing
tablets.
motions for the most part.
We are not allowed to
You're
have those tablets in our cells. That prejudiced my defense.
You were
How can I
warned.
work on my case? How can I look up certain case laws? How can I do any of this
This wasn't a
if I don't have
problem
full
2
access
weeks
to it?
ago when you were firing your attorneys and the judge warned you that you'd be at a distinct
I even
disadvantage.
suggested
You
some type
said,
of order that could be
okay,
made by the
I
court
want to represent myself.
to allow me more time out of my cell, or to talk
It's
to
your
jail
fault.
administration about allowing me more time out of my cell to be able to use those when needed. And to be frank, in a proceeding of this magnitude, there should not be even a time where I don't have access to the materials that
I
I
think
need.
we're watching Jimmy Stewart here.
If I'm not in the
Or-
courtroom or sleeping, I should be awarded the time to work on this
Was
case.
it Strom
seeing as how
Thurmond that did a
I only had a couple
24-hour
days to prepare for a trial of
filibuster?
this magnitude. Which brings me back again to the change of venue again. Even right now with trial going on, there's still political ads being shown every day that reference
He
this
couldn't
incident.
filibuster the Senate because I don't think he'd be capable
There's
of
still
reading Green Eggs and
talk
Ham.
throughout the jail about it.
Talk throughout the jail. How does that
There's
prejudice you? The jail isn't
been
your
a ton of
jury.
hate mail received to the jail since the beginning of this. It did die down for a little bit, but it picked right back up the closer we got to the trial.
But is that going to the jury? Does the jury know about the hate mail?
Mail that comes from people
This
right
is
here in the
irrelevant.
city of Waukesha. Which gives more credibility to the venue needing to be changed.
When you commit such an
Yet
infamous
still,
crime,
that was denied.
changing venue does nothing. Everyone in Wisconsin knew about it.
It's impossible for impartial jury to be found in this county, and that's not to discredit people in the county that can be impartial. It would be unfair to say that no one can be impartial. That wouldn't be accurate. But with the level of scrutiny that this whole incident has, the reporting,
And you
the
could
Facebook
have
groups,
participated in the
constant-
jury
there were
selection.
Facebook groups created because of this.
But you didn't. But now you complain they couldn't have possibly seated a
The reporting
unbiased
live stream
jury.
on Court TV has comment sections
But the jury's not on that.
where a lot of insensitive and nasty things are said.
The jury is not on that. That's irrelevant. Yes, people
The
hate
sheer
you.
insensitivity of some of the things that are
Oh, they're
said on there.
insensitive to you? Is that why you come back crying after lunch?
I know a lot of people probably don't care about what I'm about to say, but it still needs to be said because it's truth. The fact of the matter is,
It hurt his feelings.
that I have children too.
Are
Family
they
too,
on the
loved ones too,
jury?
that
You
also
have
have
children from
been
when you
ridiculed and had their
statutorily
names
are
drugged to the mud
a
and have
15-year-old.
threats towards them.
That's your fault. You are a terrible father.
Loved ones that had to leave their home
You
because they're getting
killed
threats thrown through their
6
mailbox.
people. But we shouldn't have a trial
Children that didn't feel
because
safe going to school because they were getting bullied behind what was being said.
we shouldn't have a trial because
And that's not to sweep
it
anything
harms
under
your
the rug
children. But you ran your car through a parade
whatsoever.
of 6 people, killing 6 people. But your children are the victims. They're your victims.
To constantly say and report this incident as attack, terrorism.
Is that
It's unfair and it's insensitive.
has that been said in front of the jury? It's always been an incident. Did something happen? It's not.
Definite.
Did you see an act of
Definite
terrorism?
Definite.
Did you see an attack?
And that will never be swept under the rug.
That's irrelevant.
There's always going to be healing that has to take place.
So let the victims heal. Stop grandstanding.
It's going to be difficult. And that should not be swept under the rug whatsoever.
So because a trial is difficult, a subject matter is difficult, we
But
just
it's very
shouldn't
insensitive
confront
and
it.
unfair to not recognize that there's many
It's
other victims
insensitive
that
and
never
unfair.
is talked about.
Earlier in the rant, there's no victim. There's no victim. Show me a victim. It's got to be dismissed because there's no victim. But it's insensitive and unfair.
And for people to paint a certain picture, mostly from this county, to put this picture out there.
It's not mostly from this county. This
It's
is
not only
worldwide, right,
But
Darlene?
it's insensitive and it's not true.
But it's not coming in as evidence. Media coverage is not evidence.
I'm sure the court read through the motion for change of venue.
And it
I'm
denied
assuming-
it.
Though it was a lot of paperwork in those motions. I think it was obvious
Oh, you think it was obvious.
that the venue should have been changed.
You think it was
Obvious.
obvious. Why?
It's too
State the
many
law.
connections and it's too close.
State the
It's
law
too close.
for venue change.
If there was any chance
Oh,
for
any
a fair
chance
trial
is the
and an
standard.
impartial jury,
Any
it should not have
chance
been in
is
this
the-
county.
That's not the standard.
But yet it was denied.
You couldn't have got a more
Without
impartial
any
journey in the
validity.
adjacent counties either. When you commit such an
Zero.
infamous crime,
There's so much bias that's going on that
you say it's bias. Just because it's not going your way doesn't make it bias.
and even with all this, for the record,
Oh, for the record.
we still have no proof of jurisdiction.
You haven't brought a proper argument that there's no
We
jurisdiction.
still have no bond on file in the docket sheet. We still have no plaintiff. We still have no claim.
He spent his time writing down this rant instead of reading what hearsay is.
We're not sure
And notice Judge Darrell still
of
hasn't
the
said a
relationship
word.
between you, Your Honor, and a father of one of the people that was injured. We're not clear on that relationship.
She
no matter
disclosed it
how well-prepared
earlier.
the speech was
She disclosed it when you had
It was
attorneys.
a prepared speech.
You
that was
bringing it up
obvious.
again now. She already disclosed
Where's
it
the
and determined she doesn't have a bias.
I just asked that same question.
If you don't like her ruling,
Can an
appeal.
affidavit be given?
Judges
that
don't
there
give
is
affidavits.
no bias, no conflict of interest, and no interest in the outcome of this case.
What would her interest in the outcome of the case be? Do you think she gets a bonus for convicting you?
There's no proof if you hold the full judicial power of the state, or is it the military power?
Seriously?
Mr. Brooks, I've given you about 50 minutes to.
The military power? This isn't a military
arguments.
tribunal.
You've now repeated yourself a number of times, so I'm going to turn to the state to see if they have any response.
Every word of
Go
what
ahead.
he
Thank you,
just said
Judge.
is bullshit, and
Judge,
should
I'm going
be
to
ignored.
summarize what I just heard by quoting from a case from the Eastern District of Wisconsin, federal case found at 2022 Westlaw 3045190.
Can you repeat that last?
I'm
one
so
more time?
sorry. 3045190. Retzloff versus Moran. This case is talking about many of the topics that Mr. Brooks has now recited to the court, and simply states the majority of Retzloff's filing is incomprehensible jargon and cut and paste legal mumbo jumbo.
Brilliant.
Sovereign citizen theories are frivolous and
Brilliant.
wholly without merit. The court goes on to cite to Bay, B-E-Y, versus the state of Indiana.
That was the
at
perfect
847,
citation.
Fed 3rd, 559.
Sovereign
On pages
citizen
559
mumbo
through
jumbo.
560, a 7th Circuit Court of Appeals decision from 2017. Mr. Brooks knowingly.
Didn't call out that name, nor do I know.
She let you talk for almost an hour.
The courtesy of not interrupting the state as they did
You
not
ranted
interrupt you
for over
the
an
almost
hour.
50 minutes that you spoke. Thank you.
The judge didn't
Please
interrupt
continue.
you. The prosecutors didn't interrupt
Your
you.
Honor, the record is very
Shut
clear
up.
that Mr. Brooks knowingly, willingly, voluntarily, and intelligently insisted on representing himself in this trial.
Exactly.
He has no constitutional right to stand by counsel, none whatsoever. The court patiently went through the form and advised him of many of the things he's complaining about here today, the resources of the state, the knowledge
I
of the law.
don't know that he's
his
going for a mistrial.
ignorance of the law.
He wants
And his
dismissal.
words to this
He
court,
thinks he's entitled
and
to
I
dismissal.
quote to the best of my ability, it don't make
But-
me flinch one bit.
Oh,
That's what he told this court, whatever it was, 2 weeks ago. Now he's here complaining over and over and over again how unfair this is to him. It's highly offensive. I don't know,
Yes.
because unfortunately I was talking to my
Yes.
investigator. If he accused this court of treason,
yes.
but I certainly heard that word come out of his
Yes.
mouth, and it is absolutely shocking that he would throw such a word around so loosely in this courtroom. This court has been exceedingly patient, exceedingly respectful.
She gave him almost an
His
hour to
rights
rant.
at every turn. At every turn.
I
want
love
to
this
address
prosecutor.
This claim that he only had 3 days to prepare for
He
trial.
had 11 months.
It's absolutely a false statement. The record should reflect that he does have 3 banker's boxes on his table. The record should reflect that every time the state calls a witness to the stand, he swiftly and easily turns to those boxes, which appear to be alphabetized or organized in some fashion by the public defenders who turned it over to him, and quickly removes the folder
She's
of the witness who's
furious.
testifying and effectively cross-examines that witness using
And she's
notes
not taking
from the public
any
defender.
of his
We
nonsense.
know that because he's tried to confront witnesses with the notes from the public defender. He is not going into this blind or with one arm tied behind his back. They did all the homework, and he's simply sitting here reading their notes, reading their cross-examination questions, and asking the questions, and then going on to his ridiculous questions having to do with his belief in the sovereign citizen movement.
It's not effective, but
There's no way this record would reflect that this defendant is not adequately prepared for trial.
asking the right question. You don't
He's
have
never
the right
asked
to
for a
ask
speedy
the right
trial.
questions. You have the
He
right
makes
to ask.
conflicting statements. On
questions.
one hand, you violated his rights because it's taken us so long to get to trial.
Exactly.
And on the other hand,
you have to
we're rushing
invoke.
him to this
speedy
case, and he hasn't
trial.
had adequate
You
time
have to
prepare.
invoke it.
He is not denied access to legal materials in the jail. The record is very clear from the jail administrator.
who they had
It should not be
testify before
confused.
the trial
He
started.
misleads this court intentionally to say, I only get out of my cell 2 hours a day. That is a fact. That is for his own safety, so that other inmates do not inflict physical harm upon him. He has access to a tablet.
Even
He
the
has
inmates
access
hate
to
him.
a computer. Whether he chooses to ask for those resources
Which the
is
jail
up to him.
administrator testified. He didn't
I would
ask
also
for
cite
it.
the court to U.S. XREL George versus Lane, Lane, 7th Circuit Court of Appeals at 718 Fed 2nd 226, where a pro se defendant attempted to complain on appeal
She said pro se, not pro per.
about his lack
doesn't
of
count.
access to a computerized legal research system, paralegal training, or law school
Oh,
education.
jeez.
The court rejected that contention and said,
You
once
could have
a
had a
defendant has
lawyer.
asserted his right to refuse counsel and conduct his own defense, he has no constitutional right to access those resources. And again, you warned him, Judge. You fairly warned him.
Over
And
and
he
over
basically
and over.
acted
She
as if
held
you were insulting
two
him and said
long
it didn't make him flinch
hearings
one bit.
over 2 days, warning
Much
him.
of the last 50 minutes, which this court has graciously extended him the opportunity to go on and on and on, is nothing more than legal mumble jumble. He's reading from some typewritten transcript. I can see that from where I'm sitting. I don't know who's giving him these materials.
Sovereign citizen jailhouse
But
lawyers.
he has an agenda here. It's to stall, delay, disrupt, intimidate, and it's not going to work. Thank you.
Your Honor, that's a load of crap.
He's the expert on a load of crap.
50 minutes.
I just want to object to
You
the-
just
the
want, but she
disrespectful
doesn't have to
comments
give you
that was
anything.
just made. I'm not
Disrespectful
trying to
comments.
hold you
This
up
court
from
is biased.
what you're
This court is committing
gonna
treason.
say, but that's a load of crap.
Mr. Brooks,
For her to sit there,
Mr. Brooks,
for her to sit
your
there,
objection is noted.
for her to sit there, Your Honor.
It's my turn. Let me go through this. I graciously
I'm not
gave
interrupting
you
you, Judge.
50
I'm not
minutes
interrupting you, Judge.
to raise all these various points that you want to
And
bring
she's
up.
done.
I then gave the state an opportunity to respond. That is the proper procedure. I followed decorum. I followed civility.
She did not say a word.
I did not interrupt
interrupting
you.
Not
The state
one
did
word.
not interrupt you.
There wasn't
Your
a peep.
objection to their characterization, it's noted for the record.
And
I
irrelevant.
am going to render a decision at this point. Please listen and please do not interrupt.
Oh, he's going to.
As I indicated,
I
The
guarantee
defendant spoke
every
for
other
about 50
law
minutes,
tuber in the sovereign citizen
raising a
area.
litany of complaints
Artie's going to cover
and
that rant.
issues
Natalie's
and
going to cover that
theories
rant.
regarding
Rob from
his
Blonde
view
Lumber is
of
going
how
to
this
cover that
case has
rant.
proceeded.
Mike's going to cover that
Many
rant.
of these issues, if not the vast majority or even all of them, have already been addressed by this court
Hell,
in one
Johnny Carson's
way
going to resurrect
the
and cover
other.
that rant.
Looking at, for example, his complaints about change of venue. It is true this court denied the change of venue motion.
Properly, I'm
The
sure.
court made a record at that hearing. I stand behind that record and that decision. The arguments made regarding that decision, which I would note he has yet to file an interlocutory appeal challenging that, are nothing more than speculative without a basis in law or fact. To say that this jury is biased would be a complete miscarriage of justice and a mischaracterization of the process this court painstakingly took in order to obtain a fair and impartial jury. There is absolutely nothing on this record before the court throughout these proceedings to suggest
He's
that this is a
going to,
biased
but
jury. I stand behind my previous determination
luckily
and
he
the
can't file those
process that
appeals,
this
so
court went through,
it's going to take a
including
while.
initially calling an unusually large panel
They sent
for
out
which the clerk of
questionnaires
court's
to
office sent the initial
hundreds
qualification
hundreds
questionnaire,
of
and then
potential
ultimately
jurors.
a case-specific questionnaire was sent to approximately 1,400 jurors or potential jurors.
That's massive.
There was ample opportunity for the parties throughout the proceedings leading up to the end of August to review those materials. There were numerous strikes for cause that this court entertained.
But you didn't
Even
participate
prior to that
in the
specific
jury selection.
hearing, the parties met, they conferred. The
You
state agreed
chose
not to challenge the
not
vast
to
majority
participate.
of the challenges to jurors brought by the defense. And then there was the hearing. Then this court, at jury selection, allowed for an indefinite number of strikes for cause. Many were granted, if not all. And then
We couldn't see this.
even
of
on the
course.
day that the jurors were brought in, the court provided the jurors with a supplemental questionnaire dealing specifically with the issue of exposure to the political advertisements. And then each party had the opportunity to exercise 10 preemptory strikes, which is well above the number of strikes allowed for by statute, which would be 6 based upon the homicide charges, 1 extra for the alternates, which would be 7. But out of an abundance of caution and in the interest of justice, the court gave each side 10, for which
She is
many of
so
those
good.
Mr. Brooks chose not to exercise. And then pursuant to state law, the clerk of court chose names to strike by lot. Again, there's nothing on this record before the court to suggest that this jury that we have is anything but fair and impartial. And I take issue with the characterization that they are anything but. They've been diligent, they take notes, they are attentive. They come to this court, as the case law says, there's a presumption that they come to the court without bias. And it's through the jury selection process that the parties and the court ferret out that bias. Many of the jurors who were brought in were struck for cause. Many others were not. But ultimately, we have a fair and impartial jury. As I listen to the litany of issues and arguments and complaints raised by Mr. Brooks, I would note that they are all unsubstantiated, conclusory allegations and assertions without an adequate basis raised in law
Well said.
and fact.
Well said.
There's been several misstatements by Mr. Brooks regarding either the record that's been made, items that's been provided to him, or the basis for the court either sustaining or sustaining, I should say, or overruling objections.
It's
for an example.
infectious.
There's been a mischaracterization of his rights that he claims to have. As I have stated repeatedly, your constitutional rights are not absolute when you're in a criminal trial, meaning your First Amendment right is not unfettered. It is frankly no
And you've
different
completely
why the case
misstated
law
the
is very
Sixth
clear. You
Amendment.
can't yell fire in a crowded theater. No one has a First Amendment right to do that. In a criminal case, the parties have an obligation to follow not only the Constitution and the statutes that are applicable,
He's going to
but to
have
follow
an unholy
criminal
meltdown.
procedure, the
Darlene.
rules of evidence. That is what circumscribes
But they'll
the
have
rights
6
that a
bailiffs right
defendant
behind
or
him,
the
ready to
state
go.
has in a criminal trial. The issues you raise, for example, regarding subject matter jurisdiction are baseless, they're frivolous, and they're not anything this court needs to address further.
Exactly.
The fact that
She's
you
done
now
with it.
are asking questions about whether this is admiralty court or a military court or a court of competent jurisdiction is frivolous. This court has jurisdiction over the criminal cases brought before it by the state of Wisconsin. In this particular case, these are allegations that criminal conduct occurred in the city of Waukesha. The city of Waukesha is within the county of Waukesha. This court sits as an elected official in the county of Waukesha to hear these types of cases. That is clear.
Boom. That's done.
The only argument or relief that I could discern through the course of those 50 minutes was Mr. Brooks's request that this case be dismissed for lack of subject matter jurisdiction. And as I have just indicated, this court has jurisdiction. It's not been raised. Let me rephrase that. The issue has not even been raised properly. There's never been a written motion. There's never been even an oral motion that would comport with 80201.
He hasn't
Which
stated
requires
the law,
that the
case
basis
law, the
for
basis.
the relief being requested be stated with specificity and be based in law and fact.
Simply saying, I don't think you have
The
jurisdiction.
vast majority
isn't a
of the
motion.
points that you
It's
raised,
nothing.
sir,
It's
are issues that you can raise on
conclusory.
appeal. It is true. You have a right to an interlocutory appeal. I would not be the judge to decide any of those issues. So the fact that you complain about what I do, it's noted. The record is going to be very clear. All right. I have a court reporter who's
They've
taking
kept
down
such
the
a
record of
complete
everything that
record
is said
that
and
it's
done in this courtroom when we are on the record. And so I don't have
yet he
to
keeps
all
going
the
even
time
after
say
they go
it's
off the
noted for the
record.
record because we're on the record. I sometimes do that to hopefully make it clear to you or to note it. I don't always do that, but I'm not required to do that. You raise issues concerning, I guess, plea bargaining. I have never been made aware that you would want to change your plea in this case.
But you're not
And
entitled
that you're not
to
aware
a
of the
plea
state wanting
bargain.
to do that.
The state does
That is
not
the first
have to
time
give you
any such issue has been
a plea
raised.
bargain.
And I see it as a
You could have
distraction
pled guilty at
and
any time.
as
That was
simply a
your
statement
right.
made by you as part of the litany of things that you are not perhaps pleased with. As far as my conduct in this case, I already addressed those issues. I'm not going to revisit issues related to my familiarity with the father of one of the victims. That was done very early on. I made a very thorough record, and I gave the parties at that point an opportunity to address that after they had ample time to digest that information. While it's true you have a right to seek substitution of judge, it is not unfettered. There was a time limit for that. In fact, it was exercised because a prior judge
She
was
hasn't
assigned to
even
this
zapped
case,
him yet.
and your attorneys on your behalf exercise that right of substitution. So to say that you have the right to seek recusal at any time would be a misstatement of the law.
Exactly.
And even if you think that should be exercised or there is a valid claim for that, sir, it's not been raised in the proper way before this court.
And by now it's waived.
This
You can
trial
appeal the earlier decision.
will keep going. I still expect the basic rules of civility and decorum to be followed. That includes,
can't.
sir, that when there is an
He's
objection to
incapable.
a question that you ask, that you wait for the state to indicate their objection and the basis for
that
it.
means
If I
don't
need additional
shout grounds
information,
as they're saying
I will
objection.
ask for it. If I don't need additional information, I will rule on it. And I do
You
expect
shouting
that
grounds
even if you
adds
disagree with that
nothing.
ruling, that you will abide by it and that you will
And the
move
squirrels
forward.
out on the driveway. Just
Whether
so
that's
you know.
asking a new question, rephrasing a question that you've asked, I do ask that you follow that simple rule of decorum. And that's you not interrupt, and then you follow the rules of procedure.
Exactly.
As far as the other issues you raised concerning your right to assistance of counsel, the record before this
She
court
held
over the
2 full hearings
many
on it.
days that topic has been raised, even going back to the 2 afternoons of hearings this court held, I will not revisit those. I believe I honored your request to represent yourself as is
She
required
did
by
everything she could to
the
convince you not
Constitution
to.
of not only the United States of America, but the Constitution of the state of Wisconsin. And that you made a very deliberate choice after being fully advised and aware of all the requirements that I needed to go through under the case law, both case law in the state of Wisconsin and case law from the Seventh Circuit Court of Appeals.
Exactly.
Not only guides this court, but this court must follow. I agree with the state and would draw your attention to the 2 cases that were cited.
It's sovereign citizen
United States
mumbo
ex rel.
jumbo.
George versus Lane, found at 718 F. 2nd 226, and Retzlaff versus Moran, found at 2022 Westlaw 3045190. I let you put on the record all of those points in order to give you that opportunity to make a full record of the issues that you have believed that you are entitled to raise.
And she's not going to
But
give you
those
time for that rant again.
Sovereign arguments regarding written findings of fact, bill of particulars, regarding contracts that you enter
Regarding
into, regarding
capital
admiralty
letters.
court, etc. They're baseless, sir. And this court need not
It's
address
made up.
them further.
Completely made
Now, with
up.
that, I know it's 11:30, but I would like to get one more witness on before at least we break for lunch. The jury, of course, has been out for quite some time. So I'll instruct Madam Clerk to bring the jury out.
For the record, you're done.
Bring up the Higgins Levine
You're done.
415 US
You're done.
533
The
decision.
jury's
that
on
was
its
that was
way.
not addressed, and the issues are still not addressed. There's still been no proof to anything that you said, anything that the prosecution has said. It still hasn't
There's
been.
no
Noted,
proof
and
to
we
what
will
you
continue. Bring the
said.
jury out, please.
There still hasn't been.
There's
Mr.
no
Brooks,
proof to what
I've addressed
you
them
have said.
There
to the
still
extent
hasn't
that
been
I
any
will.
proof.
The
There still hasn't
jury's on
been
its
any proof.
way. Shut up. Gag him.
I never once.
Gag
The
him.
comment about me not flinching was when you said that there's 66 years of experience at that table. That's
Gag
the
him.
comment I said that doesn't make me flinch. That was mischaracterized. That should
Gag
be for the
him.
record. There's still
Noted.
been no proof.
Mr.
About-
Brooks, please stop. I'm not going to address whether there's verified proof or not of jurisdiction,
Because
whether
it's not.
there's anything along those lines. It is frankly not required under the law. You may
Gag
disagree
him.
with that. You can take that up on appeal, whether that's an interlocutory appeal or whether that's a direct appeal if there is a conviction. But I'm not going to address it any further.
She doesn't
Because there's
need a
no
gavel.
verified proof.
She needs
There does
Blue
not
Bacon's
need
big
to be,
bopper.
sir. All right, I
It does
believe the
need to
jury
be.
is coming out. Is that true?
In order for a case to,
All right.
Try.
The
To
record
go
should
on, there should
reflect
be
that
proof.
the jury is coming out and we are about to continue with
Judges
the state's
do
next
not
witness.
provide
was the
proof.
plaintiff address. That wasn't addressed.
It was. She
Where's the
said
plaintiff? Where's the injured
it's
party?
nonsense. The injured party.
The
The
jury
are
will
the people you
disregard
get
the statements
shot.
presently being
up.
made by the defendant.
Because y'all don't want the jury to know the truth.
The
Shot.
jury will disregard those statements
I understand.
made by the defendant.
I see.
It is not his opportunity
he
to
just say he
testify. They are
understands?
comments and as such are to be
Did
disregarded.
he just mumble that he understands?
Ain't gonna work.
All right. Thank you, everyone. You may be seated.
And notice how she just completely
Not
flips
gonna
the
work.
switch and is completely pleasant
Attorney
with
Opper,
the
you may
journey,
call your next witness.
with the
Thank you.
jury.
State calls Hope Evans.
All right. Good morning, Ms. Evans. If you would please make your way to the witness stand. It is up a riser, so be mindful of that.
I guarantee he's
When
on
you
a
get
short
there, please
leash.
remain standing. Raise your right hand. My clerk Teresa, who's on my left, will swear you in.
Do you solemnly swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. Please be seated. The first thing I will ask you to do is to state your first and last names for the record and spell each.
It's Hope Evans Jansen. It's HOPEEVANS JANSEN.
Thank you. Go ahead, your witness.
Thank you, Ms. Evans. Ma'am, on the day of November 21, 2021, did you attend the Waukesha Christmas Parade?
We did.
And you came with your family, is that correct?
Is that a yes?
Yes, sorry.
That's okay. Thank you.
Just for the court report, if you could say yes or no. And was one of the people that was with you your daughter?
Yes.
And what was her age at the time?
Her age at the time was 10.
Okay. And was there a time when she was recording the events that were occurring during the parade?
She pretty much recorded the whole parade.
Okay.
Ah,
And
so
were
it's on
you,
video.
Were you present when this was happening?
Yes.
Standing right next to her, basically?
Sitting next to her. She was on my husband's lap.
Okay. And you could see her using a device to record the parade.
Yes, ma'am.
What
Because
type
they
of
don't
device
want
was
the
it?
daughter
An
to
iPhone.
testify.
And was that her phone?
Yes.
Okay. And
She can identify
during the parade,
that
were
this
you
is the
present when
recording
the
she
dancing
saw her
grannies
daughter
were
make.
struck by the red SUV?
Yes.
And that get captured by your daughter on her iPhone?
Yes.
At some point in time, did you turn that recording over to the Waukesha police?
Yes.
And prior to doing that, did you alter the content of the recording in any way?
No.
Was the recording that you turned over a true depiction of the events as you saw them unfold right in front of you?
Yes.
Like to display exhibit 139 to the witness only, please.
Go ahead.
And ma'am, it should be on the screen in front of you. We're going to just play it for just a few seconds first to make sure you can look at it and identify this, that we're talking about the same video you provided in this case. Okay. So
Yes.
we'll play about three or 4 seconds worth there. All right. Does that look familiar to you?
That's
Yes.
a good
Okay.
question.
Is this the recording that your daughter captured
I
that
assume that the
afternoon?
stenographer is writing
And
ass,
same recording that you turned over to the Waukesha police?
but
Yes.
I
All right.
could be
Move to
wrong.
admit number 139 and permission to publish.
Objection.
Exhibit 139 is received. Permission
Once
to
again,
publish
he
is
doesn't give his
granted. The objection
grounds.
is overruled.
Your Honor, this particular recording is 15 seconds in.
Okay, I'm gonna pause for just a minute. I'm dying here. I've got to take, as the court says, a comfort break. So I'll be back in just a minute. Okay, I'm back. I was really hoping the judge would declare at lunchtime after ruling on his rant because I was dying. But
Duration, I'm going to
Here we
ask
go.
that it be played with the volume on.
Go ahead.
so this is the sound of the video of the dancing grannies. Oh, and she can't watch it. She flinched and closed her eyes and is crying. That
Sevens, is that what you remember seeing that afternoon?
Yes,
Did you hear those loud thuds?
yes.
Thank you. I don't have any other questions. Mr. Brooks may have some questions for me.
Any cross?
Yeah, and I object to being called that name again, and I
You're-
don't consent to it
who
again
cares?
for the record.
Who cares?
Noted.
Just a few questions. Do you recall about what time you arrived at the parade that day?
No. Before it started,
Do you recall how long you were there before the parade actually started?
After
to
you
get
ended
underway?
it.
not really. I don't recall.
She was there during the pertinent
And
time.
who all were you with?
My
Who were you with?
family, my friend's son, my daughter, my husband, my mother-in-law, myself.
Wait, she was with herself? She was with the living person?
During
She
the
didn't send her straw man?
parade, were any of you or your family injured?
No,
They saw you injure the dancing grannies.
Do you recall seeing a vehicle approaching?
yes,
And about how far was it from you when you saw it approaching?
roughly like, I don't really know of an estimate of the amount distance. It was roughly when it started hitting the dancing grannies.
Did you see the vehicle strike anyone before that point?
No, the crowd was rather large at the parade.
So you just saw
Do
it
you
hit the
remember
dancing grannies.
the large crowd? Do you recall it being pretty loud at that point?
Every parade I've been to has been loud in general, so
So it'd be fair to say that that one was pretty loud.
yeah, I suppose.
But did you hear horns honking?
Do you recall what you did when you saw people being struck?
What do you mean?
My husband pressed my daughter into his chest so that she couldn't see. I passed her to somebody behind me, and then I got my mother-in-law up to go inside of the karate studio that we were
Won't
sitting in
somebody
for,
please
as well
think
as
of the
man that was
horn?
with us.
Because that excuses his actions. As long as you're hitting a
Do
horn,
you recall how
you
long
can do whatever
were
you
in
want
the
in your
karate
car.
studio?
No,
Was it briefly, or
we were in there until we were told that we were able to leave by the police.
did you hear
So
at
once the
any
scene was
time
declared
a
safe,
report of shots fired?
No,
once again,
Did
he's
you hear any
reminding the
shots?
jury
it was loud
that
and
shots were
chaotic.
fired.
I can't say for sure if I heard shots or not.
This isn't a good fact
So
for
would it
you.
also be fair to
Don't
say
bring
that
up
if
the
a
shots
horn had
fired
been blowing,
again.
you wouldn't have heard that either?
I would have heard a horn. We weren't that far from where the vehicle came through on the road.
So it'd be fair to say that you think you would have heard a horn, but not shots.
If shots were fired down the street, she said she didn't hear a horn.
I don't know if shots were fired further down the road or if I didn't hear any shots when the car went past.
No, I'm not asking when
She
it went past. I'm saying
she
the
says
question
she
was
did
at
not
any
hear
time.
shots
So I should have
fired
been more clear. I
or
apologize.
a horn honk.
At any time during that moment.
There were no
I
shots
don't believe I
fired
heard gunshots.
when it was
I've never
when you were by
heard a
her.
gunshot before, so I can't really say yes or no.
So it'd be fair to say you wouldn't really know what a gunshot would sound like.
Why are you fixating
Correct.
on the gunshot? This is not a good fact for you. He's reminding the jury that they wished the gunshots had hit him instead of just the car. Yeah, they need to pull the
Seeing
horn
as how
off
you-
the
you've
vehicle
never
and
heard a
honk it in
gunshot
court
before,
so that
would you-
they know what it sounds like.
Would it be fair to say that
No.
it might be really loud?
She said it was loud. She said
I
it was parade
wouldn't know.
level
I've never
loud.
heard a gunshot, so I wouldn't be able to guess.
Do you recall if it was any music playing?
It was a parade, so
Well,
there was music at some point. Marching
coming from any of the vehicles in the parade?
I don't recall at the moment.
There was. It was Jingle Bell Rock, I think, is what the Dancing Grannies were playing. Because we did hear sound earlier, but that might not have been right in front of her.
Do you recall about what time you and your family left the parade?
She answered.
No.
She doesn't remember. Asked and answered.
Do you recall making a statement to law enforcement at any time during the incident?
No.
After
The incident, the days after?
When I sent the video in to the police department,
She just
is the only time
she
I
just
talked to anybody
mysteriously
about this.
appeared with her video today.
Do you recall when that was that you sent the video in? Was it a few days after the incident or a week or two? Or
I don't honestly remember.
He's
Were you
either
contacted
battering
by
or
law
wasting
enforcement about
time.
any
There's no
follow-up to
in
the video?
between.
No.
Why would she? She's not
you follow up
investigating the case.
with law enforcement about the video?
She
No.
said no. She's not investigating the case. She doesn't need to follow up. If law enforcement needs more from her, they can ask her.
And I'm assuming at some point you took that video off of your daughter's phone. Would that be fair to say?
Correct.
And did you post that video footage anywhere, social media or anything like that?
No.
Because yeah, let's put
So
it
it's
on
just only to
Facebook.
law
Hey,
enforcement
look
that the
at
video was
the
shown.
terrorizing event we just saw.
Never showed it to any other family members or friends at any point?
Objection, relevance.
Grounds.
Relevance.
Overruled. You may answer.
No.
Are her family members on the jury? What does it matter?
When were you notified that it was a possibility that you may be called to testify in this matter?
How does this help him?
I received correspondence in the mail. I don't remember the exact date of when I received it. August, I think.
So not that long ago then would be accurate.
Yeah.
Or pretty recently rather.
She just said.
Yes.
Do you recall if that was in subpoena form?
Yes.
Did it state by whom the subpoena was sent?
Probably.
The district attorney's office.
Did it have a name?
Probably.
Susan.
Is that Miss Offer? Offer?
Did you contact the district attorney's office after receiving the subpoena?
I mailed back the subpoena.
It was
and I did
preemptive.
call
He
on
ran through the
October 3rd to
parade
see if I
anticipating
would have
he'd
to
have
come
to
in,
further run from
because I had
shots
received
fired.
no notification about anything. I was told that I was going to receive a call back, and they did contact me
Obviously, she's here.
to say
There.
that I was an on-call witness.
So at the time of October the 3rd, when you did a check to see if you would be needed, is it fair to say that at that time you wasn't sure if you would be testifying or not?
Yes,
She was told she was on call. But
Did you seek to testify in this matter?
no,
she said she was subpoenaed. She doesn't say, no one gets to say, I want to testify, let me in, coach. The prosecution presents their case. Her testimony is part of their case.
And did the district attorneys ever tell you in any way that they were the plaintiff in this matter?
Objection.
those words were never spoken to me.
Are you aware of any plaintiff in this matter? Grounds,
Irrelevant.
grounds,
It's
Sustained. You
irrelevant.
don't have to answer that.
grounds for the sustain, Your Honor.
She admonished you.
Next
She
question,
said,
sir.
let it go. You need to accept that she's he's so maddening.
Did you or your husband or anyone in your family that was present at the parade file any claims on the matter?
With who?
It's such a ridiculous question that
Do you understand the question?
Not really.
Please rephrase.
At any time, did you
exactly.
file a claim?
It's traumatizing
with
to be on the
any,
stand like
I
this.
guess the agency. or
She's
anything like that
reliving
No.
in
trauma.
regards to the incident.
No,
The only claim would be suing you.
Did any information that you obtained in regards to this incident have a complaint with it?
Objection, baby.
Grounds.
Sustained is to the form of the question.
Have you ever seen any complaint related to this incident?
Same objection. Your
Grounds.
Honor.
Sustained is to the form of the question.
Do you know of any complaint with this incident?
That was, Steve, that was the appropriate way to drop the hammer on him.
not
She's
sure I
done with his
completely
nonsense.
understand the
And I hope you're
question
feeling
on that.
well, or as well as you can.
what kind of complaint. I mean,
Please rephrase.
A complaint is a legal term. Why would a witness know about the complaint? Why would the witness know about the indictment or the information? Or this has nothing to do with her.
Have you ever seen any issued charges?
No, but
in
what would the
relation to
point of
this
sanctioning
incident?
him be?
I'm sorry.
I mean, hold him
Grounds.
in contempt
I
and
did
send
not
him to
understand
jail?
What Mr. Brooks just asked, Your Honor.
That's the
I believe you said
problem.
the issued charges.
I object to that on relevance grounds, Your Honor.
Grounds.
She said relevance. It's
Overruled. She may
irrelevant.
answer.
It's a legal conclusion. It has absolutely nothing to do with her
I
or her
haven't really been
testimony.
keeping up with
It's
the news
beyond the
media on
scope of
trial.
what she testified about on direct
So,
examination.
No, I haven't seen
It's
a list
ridiculous.
of the charges.
I was referring to if you had received anything from the district attorney's office about
Why?
the charges.
She said she hasn't seen the charges. I mean, she can't mute him on his cross-examination, but I agree. It's going to have to happen at some point. She just...
Are you aware of anyone bringing any claims or suits?
Objection.
Grounds.
It's irrelevant.
Sustained, you don't have to answer that.
And how...
Grounds for the sustain, Your Honor.
it's irrelevant.
Please.
She told you to stop this. She told you once she sustains, the argument's over. Stop. This cross-examination should have taken about 2 minutes. This wasn't a major witness.
Do you recall seeing the driver of the vehicle that you saw that?
She was only
Yeah,
there
yeah.
to get the video admitted.
No,
The entire point of her testifying was to get her daughter's video admitted. This is so
Could you see if anyone
aggravating.
else was in the vehicle that you saw?
no,
Can you recall if you saw any tents to the vehicle you saw? And by tents, I mean like tinted windows or anything of that nature.
I don't recall if the windows were tinted or not.
Do you recall where the vehicle traveled after it passed you?
Further along the parade.
No, my priority at that point was to get everybody inside and make sure they were safe.
So you didn't observe anyone struck after?
Not
What
after
you
you killed
saw
all the
initially.
dancing grannies.
Correct.
It doesn't count if she didn't see all of the death and destruction in your wake. If she only saw the dancing grannies, it doesn't count. It's a mulligan.
And you stated that you haven't really been keeping up with the incident, right?
She's only testifying
Correct.
about what she saw, which is her daughter taking video of the incident.
So that would that
Keeping
would
up
that
with the incident
mean that
has no relevance to her testimony.
it was your choice to do so, or you just kind of just disregarded it?
Objection.
Grounds. Grounds.
It's irrelevant.
Sustained.
It's argumentative. It's inappropriate.
Grounds for the sustain, Your Honor.
What's a
question, please.
sustain?
After turning in the
She
the
looks
video
so
to law
uncomfortable.
enforcement, did you keep the video at that point?
Objection has been answered.
Grounds.
Overruled, she may answer.
I mean, she didn't.
The video is no longer on my daughter's phone. There's a copy on my phone that is still on there in case I needed to resend in the video. It has not been accessed since the day I sent it to the police.
So pretty much just keeping it just in case.
Correct.
Have you viewed it since turning it
She
in
just
to law enforcement?
said.
Objection.
Grounds.
Relevance.
Grounds.
She just
Been
said
asked
she
it.
doesn't.
May not have been asked, but
she
she
doesn't
answered
watch
it, so
it.
I'll sustain it.
So it'd be fair to say that seeing the video today would be the first time that you saw it since turning it in.
The
to
first
law
time you
enforcement?
saw it,
Correct.
he axes and sawed it. It's not like she watches it to wind down before bedtime. It's traumatizing. Why would she watch it? I guarantee it's not $1 an hour. It's less than that.
And
More like $1 a day.
just for clarity,
Oh, for clarity.
you are not aware of any plaintiff in this matter, correct?
Asked and answered.
And Asked and
The-
answered,
Is that an objection?
irrelevant.
The objection is sustained. You don't need to answer that.
Shut him down now. Shut him down. He's got to think how to formulate the next abusive question. Because he's going to sneak it past the judge and the prosecution.
I think you said that you were contacted back in August, correct?
Did
I
the
received
plaintiff
mail.
contact you?
With the subpoena, yes.
Do you recall before August being contacted in connection with this incident?
Objection,
Grounds.
repetitive, irrelevant.
Grounds
Sustained.
for the sustain, Your Honor.
It's
Next question,
repetitive,
please.
irrelevant.
No
It-
grounds.
Next
the
question, please.
process the prosecutors took is irrelevant. Frankly, it's getting close, in my opinion, to attorney work product privilege. Close. I'm not saying it is, but it's close.
Would you consider yourself an injured party in this incident?
Objection,
Grounds.
repetitive, irrelevant.
Grounds.
Sustained.
Reason for the sustain, Your Honor.
Because it's repetitive
question,
and
please.
irrelevant.
No further questions.
Oh.
I asked that.
No, Your Honor.
Thank you, ma'am. You may step down.
Thank you.
And once again, it's a good thing he's got that face mask on. Because if the jury saw more of his facial expressions than just his eyes, he has such
It
terrible
is just
body
before
language.
the noon hour, so this will be a good opportunity for the court to break for lunch. I will say between an hour and 15 minutes, at least for the jurors. So all rise for the jury, please.
Exactly. My Oma, born and raised in Germany.
Did
German's her first language. She has lived here in Utah since like 1952, 53. But her English is perfect. She grew up speaking German. Her English is perfect. If people ask her where she's from, they ask, "Are you from England?" Because she has perfect English. They hear her accent, but they don't realize it's German. He grew up here. He should be able to speak English. And I don't know if they're just dismissing the jury or if did she call it lunch recess already. I'm gonna okay, yeah. So it is lunchtime. With that, I'm going to take my lunch. Stop this stream. Hope to see all of you back for the afternoon stream in about an hour, half hour, 40 minutes. I'm gonna try and be fast. So I understand though, Darlene, if you go to bed, I won't hold it against you. I realize it's very late. I would have run out the door too. That was a long morning. I mean, my stream says 3 hours, 55 minutes. That was a long morning. So, oh, exactly. Substain. Substain has got to be the word of the year. So, Exactly. Exactly. And with that, I'm going to cease to exist for the next half hour. See you guys soon.